10 court is not functioning. That's it. Another one, Belgium, madam.
Which one? Bill. See, there is a judgment yesterday by the Supreme Court.
Yes.
It has to go to the assigned bench.
But if the only if your lordship is not
Maybe. That's the judgment yesterday.
no,
So let us see how yesterday only
I
there is a
read the judgment. সেটা কলে যদি ডিভিশন রে হ্যাঁ যদি ডিভিশন রে গলে তাহলে
but if it is assignment is also changed, roster is changed.
if your lordship is sitting single, your lordship can take only because of the delay. That
Let
is
us
the
see
reasoning.
how the in the administrative side how we conceive it. Let us we it's a prerogative of the Chief Justice. Let him see and what he can arrange. I don't know.
Maybe pardon to make a mention, your lordship.
Give it. If it has to come, it has to come. No problem.
My lord, this is the matter wherein Mr. Tripathi was arguing that matter, and we were directed to file the written note of submissions with respect to the retrospective application of the OPID Act. And
Yes,
my lord, the written notes we are filing.
Written note have you written the number of the
Case number.
Case number?
Case number.
Yes, usi साथ लगा दो.
Petitioner is a
Great.
lawyer, my lord. And I mentioned this matter before the lordship for last 3 occasions. The lordship
Petitioner is a lawyer means he should practice.
My lord.
He is doing something else.
353. Your lordship also had this matter. And here's the evidence. Your lordship also queried from the state council.
Now, what are the offences?
353 is the only offense.
That's
जाऊन लेगा मेमोटा मुझे इसे वेरीफाई कर ला मो नंबर घंटी नहीं मु 3 थले से देखि मो नंबर नहीं
just take it up. The
Lordship
lawyer.
has filed an IA for interim bail, Lordship. Will Lordship dispose of matter, Lordship?
Interim bail on what ground?
His wife is suffering from liver cancer,
Liver cancer.
Lordship.
लगा दो यार.
Bail, Lordship.
But interim bail लगा दो cancer. And just give that the application for verification. Let them verify and come. I'll put it on Monday. No, let it be Friday. Let it be Friday. Let them verify and come so that if at all he is suffering from cancer, I can think of it. Please give it right now.
That's it.
Just verify.
Yes.
Somebody is suffering from cancer. Yes.
Any mention from the list, item 1 to 6.
Can you taken it after? Item number 5.
5. Yes. What do you want, madam? What do you want?
Adjournment after 1.
Adjournment on the request of counsel for the petitioner. Adjournment, yes.
Item 5, item 5,
Item 7.
Item 1, virtual mode.
Item 1, yes, madam.
Malus, Mr. Panda is on accommodation. I pray the matter may be taken up next week.
Not next week on the request of petitioner. Adjournment, yes.
Item 7, my lord. Item 7, my lord. I am in virtual period. Item 7.
Yes.
I pray, my lord, let it come 2 weeks after, my lord, because I need some document in this case.
On the request of clearance counsel for the petitioner. Adjournment, yes. 7.
Item 8.
Yes.
Info and adjournment.
Adjournment. What is this matter? Do you have the file?
No, Your Lordship.
Without file, why have you come? You must know the fact at least. What is the
On
fact?
behalf of Mr. Naik, Your Lordship.
Whatever, but you should know what is the case. Don't ever come. Why are you holding file?
No, Your Lordship.
You must hold the file. Okay. Okay. And the request of.
In item 18.
Sorry.
In item 18, my lord.
You are for the.
Mr. Sarthak Naik.
Okay, then please wait because the other side I don't know.
My lord, I am for the petitioner. It may be adjourned.
8, huh?
Yes.
Okay. Okay. On joint
Malus,
request.
in the sub item, we are there.
Addend to cancel item number 20. Kindly 2 weeks, sir.
120 will come. Yes. Yes. Yes, madam. Item.
Malus, in item 8, the sub item, I'm appearing on behalf of Mr. Panda, Malus.
Which one?
Item 8.
8, huh? Okay.
Yes,
There is a request of adjournment, joint request.
Yes, Malus. There's an interim order, Malus.
Yes, interim order. Yes.
DPS.
Item 17 to 30.
Yes, now.
My lord, pardon to mention, item number 20 can 2 weeks after.
On the request of land council.
I'm named.
Yes.
31 to 42.
39.
Pardon to mention, serial number 38, my lord.
38.
On behalf of Mr. Potke, my lord. Paper adjournment, my lord.
Okay.
39, you know.
Request.
39.
39, yes.
On behalf of Mr. Naik.
Again, who is appearing for petitioner? Then you have to wait. Petitioner counsel has to be there. Okay. Yes.
43 to 49. 50 to 53.
My lord, item number 51. I am for the
50.
51.
Yes.
I am for the appellant, my lord. On behalf of Somendra Kumar Ghosh, I am praying for the adjournment of this matter.
50. 50.
51.
551. Okay.
The health issues to lumbar.
Yes.
54 to 61.
My lord, item number 58.
Obviously.
Item number 58. Permitted to withdraw with a liberty to file better application.
Yes.
my lord.
Permitted to withdraw.
Liberty may be
Very
given.
better. Yes. With better particulars and
Yes.
relevant documents.
Oblige.
Yes.
62 to 65. 66 to 69. 69.
Withdraw. 16 withdraw.
Hold on, 69.
70 to 76. 77 to 85.
77 will be taken up 2 weeks after, my lord.
You are for the
I am for the petitioner, my lord.
appearing for who is appearing for opposite party?
It's Tirtha. So I will inform him.
Okay. Okay.
2 weeks. Interim order to continue.
No, is there interim order?
No, what happened in this case, my lord? Money is secure, and he has not registered the sale deed, my lord. Thereafter, I have instructed to the PM to stop payment. That is the subject matter.
130.
2 weeks. Agia.
Is it 130?
130 haboni.
No, whatever. Is it 130?
Agia.
It's not it. On request. Huh? But you have to intimate. If he
Yes.
if he comes and
Yes.
shouts, then
No, ମୁଁ କହିଦେବି. ଆଜ୍ଞା, interim order to continue.
continue.
Oblige.
Put it for the 138 matter. Huh? Yes.
Item 85. 138 ବି ହବନି ଆଜ୍ଞା. ମୋର ପଇସା.
But it's a case of 138 only. It's a case of 138 then.
My lord, item 85. I am
Because the 138 matters if there is a stay because the statute says within 6 months. We should not say all this. That is the idea. Yes.
My lord, item 85. I am appearing for the opposite party. Today I will file the visa, my lord.
Okay. So also entered appearance on behalf of opposite party and seeks an adjournment for filing.
Item
Obliged.
84 Miller. Item
85 interim order.
item 84 Millers may be called 2 weeks after.
Why? Interim order is there.
There is an interim order.
Therefore 4 weeks.
Millers may grant 1 week, Millers, not today.
No, what is see, it's very easy for you to say 1 week, tomorrow, day after. But how much problem we are facing, do you realize?
Yes, senior, I am not conducting this matter, my senior is conducting this matter.
That's the problem. That is the reason I am very, very reluctant. Otherwise, in every matter I can give stay. There is no problem.
Yes.
But the problem, once you give the stay, it keeps pending for years and years.
Yes.
And you have seen 2010, 2012 matters
My lord,
against cognizance, stays granted. Just imagine what is happening. And this is adding to the statistics of this court and trial court.
Yes.
And Supreme Court keeps on asking the trial court why these matters are pending. And once it is intimated that High Court has said it, it is a poor reflection on us. That we are in silly matters, cognizance taking matter, stay. So this is how we have to, very careful.
Yes.
Anyway, adjourn.
1 week. No, there is an interim order.
Yes.
86 to 92.
My lord, item number 91. I have
Yes.
appeared for the opposite party, my lord,
Hmm.
whom and victim. The petitioner has got a stay order. This is a case of 376(2)(n) and 376(3) and 4 and 6 of the POCSO Act.
Yes.
Only with regard to the discrepancy in date of birth, he has filed a petition that has been rejected, and he come before this honorable court and stay has been granted. The proceeding has been stayed. Though there is a statutory period that the proceeding under POCSO Act the trial has to be concluded within a specified period.
Then it's a good reason to argue it today.
Yes, but 91 item, my lord.
Idle reach, don't worry. And mention it. I'll take it up tomorrow if possible. You be there. It will reach.
I didn't make a mention in Lordship. 80,
Because if there is a stay in this kind of matter, it has to be vacated.
My lord.
Yes.
Lordship, item 82, I'm appearing on behalf of Miss Anema Kumari Dei. I'm seeking for an adjournment, Lordship.
Okay. On the request. Yes.
86 to 92. 93 to 100. 101.
Chalo. All right.
Pardon, my lord. My lord, that is a tied up matter, bail matter. Already I have mentioned, my lord, that case is not listed till now.
Yesterday there is a judgment. Have you seen it?
My lord.
Even if it is tied up matter, it has to go to the assigned court.
My lord, tied up here, my lord.
No, there is a judgment yesterday by the Supreme Court. Just let us see how it is perceived. Yes.
I may be
Maybe,
pardoned.
my lord, I have filing memo, my lord.
I may be pardoned, my lord.
Place admission matter.
देखिए
Some place admission matter, my lord, it is not listed in the May I remember item 59, it is a compromise matter. 498, a wife has not appeared. I have instructed my client to appear through Jaipur court.
2 o'clock.
Today it is not possible. May I pray next week any day. 59.
Try at 2 o'clock if possible. Then otherwise I'll.
59 ଆସିପାରିବନି ମାନେ
ନାଇଁ
ନନ୍ଦପୁର ରହୁଛନ୍ତି unless I instruct them Nandapur to Jaipur too much distance.
Then tomorrow.
Next week asu.
Monday.
59
Monday. Okay.
Intima to continue.
I don't know, make a mention, my lord. It is a hearing matter. The date was fixed, but not coming in the list. The judgment challenging it is a criminal appeal matter. The judgment challenged by the appellant to 2 years conviction, against 2 years conviction.
Yes.
I may be pardoned, my lords.
Yes.
Item 10, my lords, it may be adjourned.
Sorry.
Item 10, it may be taken up next week, my lords.
Where were you when page wise I called? You were in the item 1 also.
My lords.
Yes, 10.
Item
10. Item 10 on request. Yes. Come.
Item 2.
May it please, my lords. The petitioners before my lord are the sister-in-law, mother-in-law, and father-in-law of the deceased girl, my lord.
How have you prepared this matter?
Lords,
The other matter you don't prepare because there is a stay.
my lords,
In this matter you prepare. Because you want to stay here. You should have prepared that matter first.
my senior is appearing that matter.
Here also your senior appears. Till you prepare. Yes, anyway. Okay.
Great. My lords. Initially, the FIR was registered against under sections 498A, 304B, 302, 34, and 4 of Dowry Provision Act. My lords.
Yes.
The charge sheet is at page 15, my lords. May I kindly see
It
the
is
charge sheet.
306 now.
306 now, my lords. Now, the relevant portion of the charge sheet is at page 30, my lords.
30. Yes.
Page 30, my lords. 30.
Yes.
Lords, 15 lines from the bottom.
Yes.
During inquiry, lords, has it? During inquiry, it has been ascertained that as there was an argument in between alleged husband and deceased Deuri, she had not taken dinner in the night, and under stress, depression, and torture, the deceased would have committed suicide. Team of doctors conducting postmortem over the dead body of the deceased has opined that cause of death is asphyxia due to antemortem hanging. Time of death is such and such. Ligature mark is such and such. Death of the deceased is suicidal in nature. During investigation, it came to light that there was amicable settlement of dispute between husband and wife twice in 7 years of marriage through family congregation. But there no previous marked incident of torture or violence against deceased ever reported or ever resolved in presence of village gentries. On previous night of incident, alleged.
Yes. What do you want to say?
Now, the petitioners before my lord are the sister-in-law, mother-in-law, and father-in-law who were not present in the house at the time of the incident also. They are no relation.
306 is not made out against them.
Not made out against them.
Then argue that at the stage of charge. I'll give that report.
Because now cognizance has been taken against them.
That's right. You have to
Now when
argue.
they
I
start-
don't know what kind of material, what are the 161 statements and all.
Milord,
I can't
born out
analyze
from the
everything at
charge
this
sheet.
stage.
cannot say
It's-
what is the quantity.
Milord, it is born out from the charge sheet that
You may not be present, but you might have abated also. Who knows?
Evidence is there.
306 only.
Milord, it is born out that the parents were not staying with the husband. Now,
See, by-
the honorable
I may not be staying. It's
No.
not necessary that for abatement you need to have a presence in the place where the all these things can only be analyzed at the stage of
Milord,
framing
from
of
the face of the charge sheet and the materials enclosed with the charge sheet, should I be made to face trial and go to the stage of charge, Milord?
Yes, you have to go.
Milord,
You have to go.
Milord,
You have to go and argue at the stage of charge. Yes, you may be discharged. That's a different story. And 498 is there.
Milord,
Allegations are against you
Milord.
are there. So that might have led for the women to commit suicide.
I have a
And you may not be present there.
Milord.
But what kind of material has come? And everything has to be seen in totality.
Milord, this is the people who are not staying with the husband and wife, and it is born out from the statements that the husband and
May
wife stay-
not. Even if you are staying far away, you can abate.
Maybe
By
the-
phone also you can abate. By
but-
your contact you can abate. You never know what exactly.
I bowed down.
So at that stage,
But I must also look at the charge sheet and the PM report, Milord, and other materials. These
yes,
notice may be issued. I may kindly pray, Milord.
you argue at this stage of right. Petitioner had challenged the petitioner is seeking quashing of the
Milord, and the
direct
husband is also on bail.
initiated,
Husband is on bail, Milord.
initiated against them. Initiated against them. Initially, the FIR was registered for LA's Commission of Offence under Section 498A, 304B, 302, 34, IPC, reviewed Section 404 DP Act. After investigation, charge sheet has been filed on 16/6/2023 for alleged commission of offences punishable under Section 498A, 34 and 306 IPC. The petitioners are the in-laws,
Milord.
sister-in-law.
Milord, sister-in-law, mother-in-law, and father-in-law.
The
Let me observe
petitioners are
that.
the in-law members of the sister-in-law, mother-in-law, and
Father-in-law.
father-in-law of the deceased. The counsel for the petitioner has pointed out from the charge sheet that admittedly the petitioners were not present at the place of occurrence. And he has also pointed out that there is no allegation made against the present petitioner in the charge sheet. Therefore, no case under Section 306 IPC at least is made out against the petitioner. I am not inclined to entertain the petitioner at this stage, where only cognizance of the offences has been taken by the court below. The petitioner is given liberty to move appropriate application before the trial court for seeking discharge. If such application is moved, the same shall be considered on its merit. You move an application I have given.
Milord, so disposing of, I may pray one more thing, Milord. The present, the IO in the present matter is harassing the present petitioners, the father and mother and the sister-in-law.
Generally, husband has been granted bail. You will get the bail. What is the problem?
Milord, may direct that.
For the petitioner further submit that the husband of the deceased, who is the principal accused as per the prosecution, has already been admitted to bail. Hence, he submits that liberty may be granted to submits that he would be submits on instruction that the petitioners would be appearing surrendering before the court on or before 15th of March and resort to the remedy available to them under law. It is open for them to move bail applications
Same
on all
day,
the
Milord.
grounds,
First
on all the grounds, including the ground of parity, including the ground of parity. Such application is moved, then shall be considered on the same day.
Milord, till then, Milord, till 15th March, no. They'll appear.
It's matrimonial dispute.
This is
Till then, no course will till 15th of March 2024, something taken about them, subject to the petitioner surrendering and appearing before the Yes.
From DPO.
Item 3.
May I please, madam? May I please, madam? Here, my lord, petitioner have filed this application challenging the rejection of petition by the learned court below, rejecting the application for taking framing additional charge under section 6 of the OPID Act, my lord.
Yes.
Your lordship may.
Where is that order, sir? Yes.
Yes, my lord. Order under Annexure 1, my lord. Running page 12.
OPID, 6 OPID Act has been framed.
Page 16, my lord. This is one. Page 16, is not coming with the definition of financial establishment.
On that region, that but I am reading, my lord. It is coming, my lord.
You are the informant.
I am the informant, my lord. The cooperative society, which is owned by the state government or central government, OPID Act is not applicable. Here it is the society formed by the accused person 2 to 4 within the family and going beyond to the permission has collected deposits from the public crores of rupees, and then after mature they have not.
Society is registered.
Registered society. Registered under the Societies Act, but not owned or financed by the state government or central government.
Then it
is OPID Act is applicable.
Not applicable.
Where the society is owned by the state government or central government, so OPID Act not applicable. If not, it is not owned by the state government or central government, it is applicable.
Show me.
Yes, I'm reading.
And so, first, factually, show me that they are not owned by.
Section 420 is there.
420 is so. 420 on other offenses are there. That is different.
I have passed a judgment in this regard. Mr. Ashwini Kumar Das was appearing. OPID.
Additional charge.
I know additional charge. He moved. PP moved.
The government should cooperate with us because our money is.
PP is not the prosecution is not aggrieved. You are aggrieved. Prosecution should have come.
Prosecution.
It is their application which is rejected.
Now, I have filed the application.
PP has moved.
Throw PP, my lord. I have filed throw PP. Without permission of the PP.
302.
The government is now objecting. This shows that then the public should get justice. But the government should see how the public should get the justice.
Yes, show me which.
First, I'm drawing your lordship's attention to definition.
Yes.
Section 2 of the OPID Act, clause D, financial establishment.
Yes.
Means an
individual
or an association of individuals or a firm or a company registered under the Companies Act 1956 carrying on business of receiving deposit under any scheme or arrangement or in any other manner.
A society owned and controlled by
a cooperative society owned and controlled by any state government or central government. Or a banking company as defined under section C of Banking Regulation Act.
That's a financial instrument. If it is owned by, if it is not owned by, then it is not a financial institution. It is not a financial establishment. Let's see. But does not include. Does not include.
Does not include.
Does not include. Okay, I'll issue notice. Let us see.
Does not include.
Issue notice. To the accused, have you?
I have added 2 to 3.
What are the facts? The
accused by forming a cooperative society within their family and with their own supporters at collected crores of rupees deposits from the public and didn't return it. Just like a chit fund.
It is smaller.
Small amount is very high because police goes into the inquiry of affairs comes 5 to 6 FR comes, police limited the inquiry on that point. But during the inquiry, the higher officers who was interested, he has filed affidavit in a CRLMP. I have filed before the High Court that crores of rupees has been misappropriated by the such persons by the different manner.
Let them come.
Yes, ma'am.
Yes. Yes.
May I be pardoned to make a small mention, my lord?
No mentioning in between. Yes, next. No mentioning.
Item 4.
Yes, 4. Next.
Item 6.
Item 6, may I please your lordship, pursuant to the order dated 16 January 2000, let me
In
complete
this
the,
case, my lord,
in this,
your lordship has directed to supervise by the SP, my lord. And SP was on leave, my lord. Also, last order, lordship will kindly.
your lordship was pleased to direct the concerned superintendent of police present OP number 5.
And as he was on leave, my lord, he has spread for 4 weeks time.
Okay.
And as your lordship has already directed that the documents which he has filed also that should be taken into consideration at the time of.
Your lordship, offense under section 302 has been
I
registered.
understand it, but that is the reason I asked the SP.
Yes, yes, my lord.
Your lordship,
He is also.
let me,
Already joined.
Why to waste time?
no, I'm not.
The SP has to do it. It has to be complied. This order.
Lordship, 2 years' time has already been
Right.
Lordship kindly, he has prayed before lordships that he will comply the order, but as he was on leave, so.
And you are seeking for, see, 2 days back, there is a judgment of Supreme Court. Have you read it?
No, your lordship.
The complainant is not satisfied, doesn't mean that it has to be transferred to CBI.
No, not about.
And therefore,
CBI.
to mitigate your apprehension, and I have directed the superintendent of police to do it.
Your lordship.
Pursuant to the order dated 16/1/2025, Mr. General and Counsel for the state submits that the superintendent of police of Sambalpur, who has been directed to investigate the offence, is on leave. Has not
was on
the
leave.
investigation as he was on leave. Hence, he seeks 4 weeks time to comply the order dated 16/1/2025. Meets the matter after a month. The superintendent of police is directed to place a status report in this regard the next day. Yes.
Lordship, a small date kindly be fixed, your lordship.
4 weeks immediately after 4 weeks. Yes.
So, your lordship, they may be directed to submit the charge sheet as much as possible because the whole point.
Why are you making?
Your lordship,
Can a court direct a police to file charge sheet?
No, your lordship.
Court has already hit.
I have asked for a status report. Let us see what is happening.
Lordship, may I be allowed to make a submission for at least 5 minutes? I want to waste your lordship time. Just
I have already passed the order. Let us wait. Why don't you have patience? The superintendent of police is going to investigate now.
Lordship, we don't have any problem by just SP to get the investigation conducted. But the sole point of the consideration is that the dead body of the 23-year-old daughter.
Again, I have heard you.
After there was a ligature mark in the middle portion of the neck.
Into all the aspects in construction.
1 minute, you tell me. This argument I have heard nothing less than 10 times. You want to repeat once again?
So after 6 months, her father had passed away due to heart attack and shock by leaving her widowed wife, and
So therefore, it has to be transferred to CBI.
But because the one of the accused person's father was serving as a joint secretary at the Home Department, that is the main point of the contention.
So therefore, I have directed let the superintendent of police should file a status report. Let us see what he is doing. The highest officer of the district I have directed. What else?
His position is was to. And your lordship has also directed that the documents which he has also filed that should be taken into consideration in the previous order.
Yes, let us see what.
Therefore, that reason some delay occurred for.
Let us see. Let the superintendent file some report. Let us see. Yes.
Oblige, Lord.
Yes.
Item 9, matter has become infructuous, hence I pray for withdrawal.
Will you withdraw it?
My lord.
Okay. Withdraw.
Item 11. So the matter relating to cryptocurrency, Malons.
Yes.
Malons, cryptocurrency has been held to be legal by the apex court. There is a judgment of this honorable court. Though it was a bail order, they said no, it's legal. So, dealing in cryptocurrency, how can it be illegal, Malons? And the government of India is charging 18% GST.
Yes.
On top of that, Malons, the government of India is now thinking of floating a cryptocurrency by itself.
What is the PCMCS banning act?
Price chit fund. They have brought us within the fold of price chit fund act. Malons, they don't understand the basic concept of cryptocurrency. And the bail order also speaks of my lords, we are dealers in cryptocurrency. No money has been taken by us. It is P2P, that is person to platform. So the money has been given to the cryptocurrency, and my lords, your lordship is aware, sometimes the cryptocurrency may go sky high like Bitcoin, and people have earned from this. Yes, currency, they have earned, and sometimes it may fall. So, my lords, this is what has happened because these people arrested him. There was a fall and there was a bigger fall. They arrested the chief executive, and so there was a bigger fall.
All of you are on bail.
All of us are on.
What is the stage of investigation?
Investigation complete.
Oh, complete.
Cognizance taken.
You against cognizance you have.
Yes.
Okay. It needs to be heard.
Yes, fellows.
Needs to be heard.
It needs to be heard.
Short date may be mixed up
Yes.
because the interim order is continuing.
Please forgive. Because see, it's very technical issue. You have to.
No, it is not a cryptocurrency. In the name of cryptocurrency, they are alluring the people. There is no concept in cryptocurrency to hold a meeting and induce the investor. And to give.
My lords, probably he is not aware of what cryptocurrency is, my lords. There is no concept. My lords, Bitcoin holds meeting in India at Delhi. My lords, I get newspaper cuttings where Bitcoin has held, it's such a established cryptocurrency, still then it holds meetings. My lords, basically cryptocurrency has been established for international, my lords, transactions. For example, I want to buy a property in Australia. Now I have to go through the rigmarole of taking permission from the RBI, going, transferring my money to Australia. Australia also has to give me permission. So these to eradicate these difficulties,
They will purchase Bitcoin and it will convert.
Cryptocurrency, and it has now become an established norm. The government of India, that means you also charge the finance secretary. The government of India is, my lords, asking 18% GST on crypto.
In the last budget, it was there.
Yes, well, and this budget, because it went up to 22%, there was a hue and cry. Again, they brought it back to 18%. The government of India itself is thinking of floating a cryptocurrency. He says cryptocurrency is illegal.
No, that is the cryptocurrency is not illegal. I am not submitting. But in this particular case, in the name of cryptocurrency, they are alluring the investors and giving the assurance to pay.
You have to answer me one thing.
Miller.
Alluring someone to invest in a legal fund.
No.
Is a crime. For example, I'll just. Suppose investment in the shareholding of a company. It is a legal transaction.
Yes.
And I don't know anything about the shareholding. You come and persuade me. Why don't you spend money there and you will get good return? I have no knowledge. I trusted you and you took my money and invested there. In the entire transaction, and subsequently I found that I lost a lot of money there. Can I prosecute you because you have allured me to invest in a genuine transaction? Genuine transaction. Is there any criminality involved in it?
No, in that case,
that's what he says. That is what he says. Cryptocurrency is illegal. If I allure someone who has no knowledge to invest that money, he has invested that money and face a loss. That is to his peril. But there is no criminality in it.
But this here is the different case. In the name of cryptocurrency, they were not transacting in cryptocurrency. They have
yes, if you can say that in the name of cryptocurrency, they have taken the money and have done something else.
That is the case of prosecution.
I'm saying, my lord, suppose I have taken money and I don't invest it in anything. I misappropriate the money.
Then there is a criminal. Even otherwise, if you have taken the money for cryptocurrency and invested somewhere else,
exactly,
there also you may be liable.
But it is person to platform. He invests. I say you invest in this cryptocurrency. All the cryptocurrencies are in a particular platform, and that is like a stock exchange. A lot of shares. Binance. Now he.
And I have a serious doubt whether there is any entrustment in these kind of cases because all things are. Platform to platform. And there is no entrustment also.
No entrustment.
It goes straight away there. You only say that you these are the domain and you just invest there.
Yes.
And from there to there, it goes there. So there is direct interest.
Just one minute. In fact, when the bail application was being heard by Justice Aditya Mahapatra Malas, what happened? He went on asking the IO, just tell me where the money has gone. Has it gone to this particular person? 3 or 4 times the IO appeared. He could not say no.
As I told you always, that neither the prosecutor nor the defense counsel, even the court also don't know what exactly the transaction is.
Well, I'm studying it myself right now just for this.
The youngsters knows everything,
Yes.
and they educate you perfectly. The youngsters knows
Yes.
the transaction and all.
No, but he could not say, because then what your lordship is saying, I've taken the money, I've not invested or misappropriated somewhere, or I've invested it elsewhere. The money has not come to me. It is their case. In fact, the IO admits in court in the bail application, money has not gone to them, but they have made him invest in this cryptocurrency.
Let us
Yes, well,
let us
this has to
see
be heard.
Let's sort that, because they.
Yes, so that is the interim management to that. Just give a flow chart kind of thing where
Yes,
things move. And all. Please just check it up. Advance copy you must give so that we can understand, because his case is altogether in different parlance.
Yes.
Let us see what he says.
This is an interesting question, your lordship, because this has not been decided.
I want to get into the root
cryptocurrency.
of the matter. What exactly has happened?
No High Court has decided. I think nowhere are they arresting people for cryptocurrency. So this is the first time this has crept up.
Please
Yes,
assist so that
certainly,
we can
certainly,
venture
certainly.
into this. Okay.
Obliged, ma'am. Interim order may continue.
You also please prepare it.
Yes.
Interim order may continue.
Yes, my lord.
Yes.
Yes, is that I had a file a petition order session 311 CRPC before the London Edition Board, sir. And as because the advocate counsel has made accident and died, and due to that reason the case was delayed. And my petition, when I saw when the brief came to me, I saw that some certain questions has not been put to the informant. As because it is 10 lakhs rupees, 10 lakhs, and it is sorry to mention here that the accused two daughters are the heart patient. One is now lying in the Madrasa for a plantation, heart plantation, and he is now there. My submission is, my lord, that one stay may be granted, as because the learned edition is threatening to issue NBW, and the accused is not here at accused petition, and he is now in the lordship.
Mr. Rai, when you say judge is threatening, you should be careful.
No, I will issue NBW.
Why should anybody will threaten you?
As because delay is coming. I was not there.
Language is not proper.
Advocate was there. He accidentally he has died. Sorrowful, madam. Sorry.
That's right. But see, the long and short of the matter is you moved an application for recalling complainant for
yes, I have filed recalling and question.
It is a 138 NI Act case.
Yes.
Isn't it? You are the accused. You are the accused.
Yes.
And all other considerations are irrelevant.
Yes, stay may
And where is the complaint?
So, for complaint, after granting the stay, they are issue, someone may be issued to him to appear in the next.
I'll just issue notice. Yes.
My lord, stay may be granted.
I know. There is no question of stay in 138 matter.
15 item.
It's all 15 matter.
In 20 parts, the case is put in 20 parts.
1 minute. Yes.
6 years he have waited, my lord. After 6 years, the 315 petition was allowed. There is a belated stage at the time of Harman has filed the recall of the complaint after 6 years. For that
That's
reason,
right. To what extent one can help you?
was pleased to reject it. There's 15 years also. Yes, sir.
20 parts, the case is posted 20 parts for giving evidence. Depends.
Time of what the court will do.
See, 8 years you have taken. 8 years.
The
That's the finding. How will you see? Come to the real point at page 15. page 15, the objection raised by the opposite side. 8 years you have, delayed the trial of the 138 case being accused. And other factors are not relevant.
My cases are pending in 2003. Several, I was in the company, bank, several cases, thousand cases are pending here.
No, maybe because 1,000 cases are pending, so this should also be pending.
I am not coming to that. Just I'm giving one example. But my case is that I was not the advocate. The advocate has died in accident. He was in several elements. Depression.
Sir, where have you said all these things in one your application?
Only one date, the stay may be granted.
No, that's not the issue.
Posted to any date for hearing.
You are pitching the case so high, then show me where have you said in your
several questions he has
11
not put.
application.
The question has not put as because he was a yelling person. The advocate was engaged earlier.
Show me your application under section 311. Where have you said all these things? All these emotional argument will not cut any eyes.
I have a questionnaire. I have given a questionnaire. That is the settled principle of law.
Where is that? Where is that? Show me.
I have mentioned. I am reading out. I am reading out the 2017 Justice S.K. Mishra. The delay is not a ground for allowing the.
Where is your application under 311? Show me that.
I will just put the question and the matter will be finalized. That is my case. Only one date. If my lord will allow my application, I will go. One day I will finish the prosecution and there will deliver of judgment. There is nothing. Only one date. Question
You have written so much in 311. The relevant thing you have not written. Your entire defense, what had happened, all these things are not relevant at all. Not able to comprehend what to. I'll simply issue notice and leave it like that. Okay, issue notice. Next.
Only within 20th, my lord. As because the case is posted to 21st.
Let it be. You don't have a case. I'm trying to help you out. Don't have a case. Otherwise, I'll dismiss it right now.
2 times cost has been imposed against us.
Let it be. It should be. It should be imposed. Yeah. What did they do? Next week. Yes, sir.
And the petitioner has made a prayer for quashing of the criminal proceeding.
Yes.
Specifically on the ground that a compromise has been effected and now they are husband and wife.
What are the offences?
363.
Charge sheet is filed.
No, only FIR is there. It was
I'll issue notice. I'll issue notice.
Yes.
They married her. Yes. Issue notice. Written on so. Okay. Bring him. Bring her. When?
They would appear. 10 दिन पर because she is in my house and her uncle.
You say that both of you are married. Come together.
Yes. Together. That would be more.
They are staying where? They are in Kolhapur district.
16-year-old.
16 years.
22, 16 years. Now married.
No, POCSO is not involved. So before the charge sheet is filed, you do it for
your lordship. I can fix up a date.
Once they invoke POCSO, nobody can help you. Do it next week.
Most obliged. Your lordship may kindly fix up a date.
21st.
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 Yes.
No, don't give 21st. Give it 20th. 21st. 20th. 24. Then no, 24th will be. 4th. And before the charge sheet is filed, you encash it. Yes.
40.
You hold on, don't file, Mr. Jana. Advise.
Just call for the 164.
Because what will happen? What will happen is once the charge sheet is filed, POCSO is involved, then he is in trouble, serious trouble. I don't want to don't precipitate it. At least they are married. Let them stay happily. 20th. Let it be 20th. 20th. You bring them. Yes.
40.
May I please, your
Yes.
lordship, I have been charged with 363, 366, 376 and POCSO Act 6. The trial has already progressed and both the sides, the conclusion had gone. Now we have given a petition under 311 to recall.
Where
the,
is that? Show me. I'll allow that.
32. Page, order of the lower court is in the page 32.
1-3.
Actually, the victim is already married to in my.
I know, don't, I understand it now. 30, huh?
My lord, last time
The
you have
incorrect
asked,
way of quashing.
last time you have asked me the citation, if any, to the support my claim.
Now, where is your application 311 rejected?
My lord,
PW1 is the
affidavit, that is page 30.
yes. PW1 is the victim.
Victim and as well as the informant.
And PW2 is the informant. What about they had deposed against you?
Yes,
earlier?
ma'am. Now she is married in my village and she is my immediate neighbor and she has given one affidavit that because of the village enmity we have given the year. Now we want to compromise. And
What
we
is the
want to-
311 application?
My lord, that is there, but in the judgment also, order also para 2 is there. Para 2, page 32, para 2. Learned counsel for the petitioner has submitted that
I've
in
seen it,
the
I've seen it.
meantime the victim is already married.
I've seen it. I've seen it. Yes. Subject to the Lindy research on merit he has decided.
Merit.
Assuming what judgment law.
Merit.
What is that?
And that the Supreme Court has already given a judgment that
What is it?
DY, Dr. DY Chandrachud,
What does it?
para 31 that highlighted 27.
Coming up with the position of
The principle.
What is this? What do you want?
We are allowed to recall or re-examine.
The court says that you have ample power. Everybody knows it's ample power.
That's what I'm telling you. That after the even the conclusion of the evidences also that's correct.
That is not an issue. You show me in these kind of cases where if the witnesses have already deposed against you on the ground that you have settled whether 311 can be allowed because the judgments are otherwise. Because in the application you have created a problem for yourself. You have argued that that is the problem you have created. Why have you said that I have settled so therefore I am coming? The law is
that shouldn't have been there. I told
that is the
why
mistake
you
you
kept
have
the
done.
affidavit.
You should have moved an innocent, innocuous application that I want to re-examine. It would have been sufficed.
That should have been.
And you become wiser.
My lord, they have given
Saying that she has already deposed against me, but she is now my neighbor, so I own over him. Therefore, I am calling.
That is the, my lord,
These kind of
I know. I told that
who will allow.
that agreement should not have it in.
That is the basis of 311.
My lord.
It is a dangerous trend now. You can't, you just get some judgment. Get some judgment. You see for covering up the prosecution case or this case, 311 cannot be invoked. See, there is a specific bar under section 33(5) of POCSO. Repeatedly, the victim girl cannot be called. If it is in exceptional circumstances, it is not. I have given the judgment which said that it is not an absolute bar. You can call in exceptional circumstances here. What is the circumstances you are saying? I have won over the witness. That is the circumstances you are citing for 311. Then the bar operates against you.
Now that she is married, never. That's what we are told. Actually, that agreement should not have it given.
I am with you fully. But I have to write something.
Okay, my lord. Give me
I have
some
to
time.
write justifying calling the witness.
Once there is
Overcoming the statutory bar.
Actually.
So therefore, unless you,
My lord, I will give that.
you please do that.
Okay.
Please.
Give
I'm
me
just
some
simply urging. Get some high court judgment or something.
Okay.
Yes.
50.
And here the petitioners who are the married daughters and their husbands has been implicated by the wife in domestic violence. And the petitioner number 1, who is a senior citizen and staying away because their married daughters and their husbands who are staying away from the residential house of the aggrieved person, they have been implicated in this case. And there is no allegation against them also. And the definition of share household does not meet, because not a single point of time they remain there. And they are now old and ailing persons. They have been falsely implicated.
See, matrimonial I'll just issue notice. Next.
And my lord, domestic violence case may be stayed in further proceedings.
No, stay question. You move application.
No. Because I have filed application, because my lord, because the proceeding is going on against these petitioners in court below.
The problem with you is you have implemented all the petitioners. All the petitioners. That is the whole difficulty with you.
Not all the aggrieved party. I have not implemented as a husband as a party.
No, just see the petition.
Not husband. Husband has not been added a petitioner herein. Because
there are 6 petitioners.
Yes.
And then
yes,
I can understand the domestic relationship with all the petitioner has to be looked into.
No.
In en masse, you can't file a petition and say that Quashing.
No.
Individual case you have to make out. Not that you can ask for complete,
Here the 1 to
Anyway, I have issue notice. Yes, issue notice.
1 to 4 are their married daughters and their husband. They are no way related. 1 to 4 and old, they are senior citizen, old ailing persons, and they have been implicated, and they are running pillar to post in the lower court. And for that reason, I am pressing this case, madam. And I am not. Husband is not there.
Well, who is 5 and 6?
5 and 6 are father-in-law, mother-in-law, handicapped father-in-law and mother-in-law.
Where have you say handicap?
Handicap I have stated in my petition, madam.
Where is that?
Is para 4. All along after marriage, she instigated her husband to live separately from her old and ailing mother-in-law and father-in-law, who is a handicapped person. When the husband not acceded to
application, let him move application for adjournment. Yes.
60.
Yes, sir.
My lord, in this case, I have paid for quashing a proceeding initiated against me under section 138 NI Act on the ground that since the initial deposition, the complainant has not been able to examine himself or to produce any further evidence in this regard. For the last 7 years, I have been attending and he has been taking unlimited adjournments. Besides that, the proceeding also vitiated by collusion and fraud. He is a stranger to me. He has collected a check from the opposite party number 2.
Sir, is everything all right? But you have filed only one annexure.
Yes, sir.
And half a page for the order dated 17/1/2024.
Yes,
on that basis, I'll pass a 138 proceeding initiated against you. And everything you are saying in orally. So show me any document. It is a 138 case. Well, see this order. This is a vague order. What is this order? Nobody can understand. Read it.
This
and how will relate it that with the order with the
I made an application under section.
Where is the application? Where is the complaint? Where is it? You want quashing up a 138 case being an accused?
I'll submit.
Which is going on from 2017?
I'll submit all.
Complaint copy is not there.
All documents.
The application is not there.
I'll submit all documents.
I know. Let counsel for the petition seeks an
Next week.
adjournment to file additional document to substantiate the case. Please the matter for 4 weeks. Yes.
17.
May I please your lordship? My lord, I have filed this application, my lord, challenging the order of cognizance, right, annexure 1.
Yes.
And my lord, on the ground that in the meantime, that cognizance was taken, my lord, for the commission of the offence under section 498A, 406/34 of the IPC.
You, who are you, husband?
My lord, here, my lord, three petitioners are before your lordship. One, my lord, is who is the husband, and one is his relative, my lord. He is a school teacher.
Three.
Three is the sister-in-law.
I'll issue notice.
My lord, if your lordship will, yes, my lord,
I'll simply issue notice, bring them.
My lord, here, my lord.
54.
Can I have annexed of 3 series?
He is alleging that he was with his boyfriend and.
ନାଇଁ ବୟଫ୍ରେଣ୍ଡ ନୁହଁ, ସେ ମ୍ୟାରେଜ କରିସାରିଛି, ତାର ଗୋଟେ ପିଲା ହେଇସାରିଛି, ସେ ପିଲାର ବାର୍ଥ ସାର୍ଟିଫିକେଟ ପେଜ 18
498A and everything is there, therefore I'm issuing notice. Otherwise there is nothing to quash. Allegations are there.
ସିଏ ଅଲଗା ଜାଗାରେ ବାହା ହେଇକି ତାର ପିଲା ହେଇସାରିଲାଣି, ମୁଁ ତାର ବାର୍ଥ ସାର୍ଟିଫିକେଟ ଦେଇଛି।
That doesn't mean that whatever you have done in past way.
ଏବଂ
merely because he married subsequently, it doesn't mean that 354 everything goes.
354 ନାହିଁ
Is there cognizance is taken just see?
ନାଇଁ cognizance ହେଇଛି ଆମର cognizance ହେଇଛି ଆଜ୍ଞା।
354A, 406, 34, 498A. Everything is there. Everything is there.
ଆଜ୍ଞା। ଆଉ ତାପରେ ହେଇଛି ଆଜ୍ଞା।
There we'll see. Yes.
My lord,
Why don't you settle?
My lord, I have filed, see, asunandi, cooperate କରୁନାହାନ୍ତି।
We'll see.
My lord, I have filed an IA for stay of the further proceeding.
How can I stay? For what good reason? There is nothing on merits. I intended to dismiss right now, but looking at 498A, I am issuing notice. Nothing beyond that, because all allegations are borne out from the record. It's a clear-cut case to proceed with.
But problem is, my lord, I am saying out of record, my lord, that now she has already married and she has a daughter. Thereafter, my lord, in all the proceedings, she has also filed matrimonial case before the family judge Kendrapada.
So that's the reason I'm issuing notice. Bring her.
Yes, my lord.
But try
not cooperating.
What best I can do is I will direct the IIC to serve. Okay, through IIC also. Let her come. We'll settle it out. Yes.
Piece of a date.
Yes, what date?
And in the meantime, my lord, I am filing this copy of the charge sheet.
Yes.
I have handed over the copy, my lord, to the State Council. Copy of the charge sheet.
Now you have forgotten that is a paperless court. Everything has to be filed there only. Stop this practice of giving. Yes.
I fix up a date one.
Yes. 18, huh?
May I please, Lordship?
18.
The case is the quashing of the order of cognizance on the ground of compromise, Your Lordships.
Compromise?
Your Lordships. Both the party present married to each other, Lordships. 376-1, 366, 294-506, 342-109, 34 IPC.
376.
May I please, my lordship? I am appearing from complainant.
What are the allegations? Just take it up. What are the
Lordship,
settlement terms?
In the meantime, the informant already married to the
accused.
Your Lordship.
Informant has married to accused.
Your Lordship, both parties present in this court.
Where is the affidavit? Show me. Marriage certificate is there. Registered marriage, huh? So this CORAM. Wife, yes, they are married. Huh? I'll just pass over at 12 o'clock. I'll take it out.
Lordship.
Just Mrs. Sarita Marana is there.
Today. Is another court today. See herself.
Interact with the girl. Is there any problem?
I'll go.
Okay. 12 o'clock. 2 o'clock. Okay. 2 o'clock. 2 o'clock. Let it be 2 o'clock, man. 2 o'clock. Yes.
19.
Just interact with the girl if any problem is there.
My lord, I am filed this application for quashing of penal proceeding. My lord, the affair is for non-compliance of terms and conditions of the sale agreement. On identical matter, Honorable Office Court quashed the affair, holding the civil law cannot give any criminal color, my lord. This is the judgment, my lord. The case of Radhesha.
So let us see the fact first.
Last page 18 is the affair. Second thing is there is no cause of action.
Charge sheet has been filed?
No.
So what are the allegations?
Allegation that there is an agreement to sell the land, but
the land had not been sold to the complainant, the violate terms and condition. If Lordship see the agreement,
Allegation, I page 18.
Huh?
Page 18.
Just see the allegation.
the agreement, there is no cause of action. Agreement is validity, that is 3/12/2025. There was a clause in agreement. If I will not register the land, there I will return the money along with the 15% interest. Page 27.
Just see what are the allegations.
My lord, allegation is, my lord. The first part, he has taken money and there is agreement, everything, my lord. And second part, your lordship is paragraph 3, your lordship. The antisocial and earlier also, they have also emanated some antisocial. Not only the case is registered under.
No, will not do. This
No,
is
no,
investigation.
no,
Para 3.
No, 2 lines. My lord can Peruz. He informed the IIC, informed the local MLA. He stated. Then prayer in the
So therefore, it has to be investigated to that extent.
No, there is no cause of action at all. What's the agreement?
Agreement is something different. There I am with you. There I am
Yes.
with you. It is a civil dispute.
Yes.
Specific performance should have to file. It has to be written law.
Third thing, Lordship, the cause of action Baleshwar.
I'll issue notice and give the status report. Issue
Yes.
notice,
Yes.
get the status report. We'll see.
Another prayer, my lord. I file time petition if the
Time petition where investigation is going on, higher pocket, time petition.
my lord, no, before the court below.
Where is the court below? Charge sheet has not been filed. Where is the court below now?
The case of 2024. Lordship, my humbly prayer.
Where charge sheet has been filed?
No.
Then where is the court below? You move application before IO.
No,
Please judge it.
not
Then
IO. Only prayer, my lord. Done.
what? Why should
Any court, any issue notice?
I am issuing notice? That's what I am saying, that I can't say the investigation. Okay? And the charge sheet has not been filed. Trial is not going on. Where will you move application?
My prayer, my lord.
Then I'll say you move application before the IO.
No,
IO will.
No.
And if you also file Vokalatnama there before IO. Why are you talking all this? I'm issuing notice. Let us see if you can. You have paid back the money.
My lord.
You money paid back.
Agreement about sorry, the validity.
You come with the money and pay it. Finish that. You can't have both. Either you go and register the land if you have taken money.
Dispute.
Then that's the whole
agreement.
Disputed property you have taken advance, and now you are saying this, that. Either you, if you can't sell the land,
yes,
you have taken the money, pay it back.
Agreement getting interest.
I don't know. You have whatever money you have taken, give it back. That's all.
Let them not let them appear.
But you can't hide behind the technicality. You say that neither I'll give you land nor the money, advance money, and technically no case is made out, so therefore I'm happy. You can't do that.
No.
Get ready to pay back. I record that.
Let them appear below. Let them say appear.
That's there the real crime is there.
Yes.
Your client is not honest. You have taken the money. You don't want to register the land. Now the land is disputed land. So he has rightly invoked. So I issue notice. Come with the money. Otherwise, FIR will go on. I can't help you. Yes.
21.
What is the advance money, by the way? You have taken. How much you have taken?
9 lakhs.
9 lakhs. Come with that. Huh? Yes. Next time.
May I please?
My lord. No course action at least.
Give the money, then I'll pass it.
I will 9 lakhs. I will
First deposit 9.
Yes.
Come with Monday.
No,
Monday come with.
Now
Oh, it's a papa Korea city gole kon faida.
Next date I will complete 9 lakhs.
You come, I'll put it next day. Short date here. You come with the money. I'll call him and give it and finish it up. No special voice, nothing. When have you taken that money? 2020. 23.
December 2023.
You may have to pay a little interest here and there.
Presence of SP,
6% or something.
Presence of SP, there was a compromise of 11 lakhs. 2 lakhs interest. He is not able.
I will make him agree. 11 lakhs you pay and Quashing.
Hello, one of the co-accused, Subhalam Adkatia, of this granted order, my lord.
What happened? What happened?
Only co-accused are
Uh-huh.
praying for bail, my lord. Sorry, similar orders.
What are you asking? You are asking for quashing. No. You are asking for direction to issue the trial court to consider the present petition for bail application.
Prayer versus page 4 versus
What kind of order? What kind of this thing? Continue to order by it.
and my lord.
Same order.
So not hypocrite. She already would have coordinate bench already there has directed that.
Yeah.
Surrender kara pe after extension magi chunti. There is ABL appeal party na sankar
Nama.
Co-accused granted সেটা সে যাইছে চেয়ারল এমসি যাইছে
ফাইল করলে
Shankar Lama.
সেটা 2022 that is 2022 and after this one is filed my lord.
Last order
Subla Margatti after that
No. See, earlier you approached this court.
ABL appeal my lord. That is ABL appeal.
That is rejected.
That is rejected and this is the CRLMC. By CRLMC Subla Margatti has surrendered my lord.
No, that's right. But what are you asking? Your bail application should be decided relying upon Tufan Singh.
Tufan Singh ଆଉ ସେ Subla Margatti ସେ order ରେ ଯାଇଛି praying for similar order ଆଉ କିଛି ନାହିଁ.
In that case, whether anticipated bail was rejected?
Rejected my lord.
In that the other case.
No, সেটা direct ସେ CRLMC file କରିଥିଲା. ଆଜ୍ଞା.
Then so
I have given ସେଟା
show me that out. This one?
Yes my lord. And he is accused number 6, I am accused number 7. Surrender କରିବା ପାଇଁ ତ ମାଗୁଛୁ ନା ଆଉ କଣ?
ଆପଣ surrender already ନେଇଛନ୍ତି
ଏଇଟା co-accused ଯାଇଛି ଏଥିରେ ଯାଇଛି ଏଥିରେ ଯାଇଛି
See, the problem, see, Mr. Padhe, the problem is what he says is, if you have already approached this court, you must disclose that. Then, see, if I pass some order and it goes contrary to the earlier order passed in your case, then there's a difficulty. So at least you should disclose that I had approached, this is the order and all.
My lord, on 22/11/2024, my lord. A miscase, he filed.
You please file that also.
Yes, my lord.
You please file. I'm just adjourning.
Okay, my lord.
See, without that,
Yes,
see,
my lord.
if I pass some order
I will file the IF.
and earlier order is
No,
there,
no, my lord, I will file the
it's a
IF.
very dangerous thing.
Okay, my lord.
You must disclose that. Okay. This also you file. Whatever you want to file.
Okay. I have to file.
Yes. Yes, 22.
May I please?
Yes, sir.
The second complaint case filed on self-same ground in the form of protest petition matter. Earlier, in the form of protest petition.
Yes.
Earlier, the opposite party, not who being the complainant, has filed a complaint case where the direction has been issued to the local police to investigate the matter. Charge sheet has been submitted, right?
Yes.
Thereafter,
Yes,
again, another complaint case filed in the form of a protest petition matter, where the cognizance has been taken by the very same court, where the GR case is pending. He has to file a petition, protest petition in the GR case. Instead of filing GR case, my lord, he has filed the second complaint case on same ground before the very same court.
No, it's a protest petition.
Protest petition in a complaint case.
Page 31. No, what complaint? Just see.
Earlier he has filed a complaint case by 63 of 2021.
Yes.
Matter was referred to the local police station for investigation under section 156.
And charge sheet is
Charge sheet has been submitted by the
Yes.
local police.
In that petition, they file a protest petition. What is wrong in it?
No, he has not. He has not filed before the GR case. In GR case, he has filed another complaint case. 1/24 of 2020.
But he says it is a protest petition.
Yes,
Just see.
madam. Yes, madam.
GR case. He has filed in GR case.
Not GR case.
481.
Not
Just
GR
see-
case.
Just see page 31, para 1.
Yes, madam.
Vivarani. Just see.
My lord. One CC case 1/24 of 21. madam.
Yes.
Another petition filed.
And GR case. is
Earlier
different
it was
case.
63, madam. Earlier it was 63. Now this is 1/24, madam.
124.
of 2021.
But see, the GR case is arising out of that ICC 63 only.
Yes, exactly, madam.
Then it is
Yes.
converted to GR.
He has to
Then
file a
it
protest
should
petition in
be-
GR case, madam.
or the numbering is See, slight numbering is changed, doesn't mean
Already-
that scenario changed.
Already charge sheet has been submitted on this under section for.
See, earlier, 1cc case 63 of 2021 filed. And that germinate into a case under GR, that is 481.
Yes,
Closure report was filed. He files a protest petition that is numbered as 124. What is wrong in it?
That is a complaint case, my lord. My submission is that is complaint case,
Ah,
not
no,
the
no,
GR case, my lord.
You are unnecessary. Merit, come on merit.
Yes, ma'am.
Come on merit.
Your lordship.
Whether in
Allegation is that, man. Allegation is that the present petitioners, they have taken 5 lakhs from the opposite party note 2 for purchase of the land and construction of the house. Present petitioner of 1 and 2, they are the rusty village lady, my lord. Because of the.
So, show me the complaint, protest petition allegation and 202 statement. That's all.
Yes, ma'am.
What happened in this case, Your Lordship? Initially, 163, 163 of 2021 is filed.
I understood it.
Your
Now
Lordship.
proceed to.
And 5 accused person, the police has arrested 3. 2 is left.
I understood it.
Thereafter, petition filed. Therefore, 5 has been arrested and accused in this case. Your Lordship, 202, in based on the 202 inquiry. Your Lordship.
Yes.
Your lordship, page 41, the cognizance has been taken on 23/12/2021.
That's right, but where is the statement?
Statement I have not annexed, your lordship.
Show me the statement.
Yes.
Show me this. You don't have a case. The allegations are very specific in the complaint. If 202
Matter has
that
already-
statement is there, then you are out.
Matter has already inquired into by the competent authority and.
Therefore, there is a provision of protest petition. In the protest petition, allegations are made. In 202 statement, if allegations are supported, you are out.
One time.
Then counsel for the petition submission seeks 1 week time to file the statement recorded under section 202 CRPC. Statement of the witnesses recorded under section 202 CRPC leaves the matter. Yes, next.
23.
My lord, as per your lordship, transaction I filed.
Yes.
Today I am filing the additional affidavit.
Yes.
All the petitioner and opposite party of 2 are present, my lord. Last occasion, they are
What are
also
the
present.
offences? Yes.
The lordship wanted to know the
34 and
stage of the case, my lord.
Huh?
Stage of the status of the case
Yes.
in the learned court below. Charges were framed and 6 witnesses have been examined. I have also given all the certified copies of the statements.
May I submit one thing, Your Lordship? Yesterday, I filed an affidavit regarding the status of the case, Your Lordship. That affidavit is not come on the record, but however, out of 38 charge sheet witnesses, Your Lordship, 6 numbers of witnesses have already been examined.
In total 13.
38, Your Lordship.
38.
Yes, Your Lordship.
And have you seen these witnesses, whether they have said?
That statement is not with me, but I have filed the status of the case by IAC has filed the status of the case, Your Lordship, in which they have clearly mentioned out of 38 witnesses, 6 have already been examined. But that report is not with
Now,
me.
who is the informant here?
Here is the informant, Your Lordship.
Informant is Sundar Means.
Sundar?
Sundar Means.
Means. Where is his statement?
He is present. No.
No,
He has not been examined.
Not been examined. Who all are these witnesses have been examined?
Witnesses, I have given the certified copies. Number 1 is Bani Sahu.
They have supported the prosecution.
No, they have not supported. They have no allegation against the petition number 2 and 3, my lord.
Just check it up.
Yes, sir.
See, you can't scuttle the trial in between if the evidence is going on. Because some evidence has come against you, you win over one witness and say that I have settled and quash it. That is not the 482 jurisdiction. If the trial is in advanced stage and the court should not interfere, quashing the entire proceeding because on the basis of settlement with the complainant. If other witnesses have supported the prosecution, then the trial court will look into.
No, other witnesses, they have no.
Let him examine. Let
Yes,
him
yes,
examine.
let-
Okay. Examine. File the file and counsel for the petitioner seeks to
All are
record-
present, my lord, today.
place on record the evidence of witnesses, evidence of 6 witnesses, those who have already been examined by the prosecution. Leave the matter after a week. Yes, next.
My lord, the personal appearance,
They have to come. You see, these are the offences. You should have. Why are you coming with installments? You should be ready with the matters. If the trial is going on, witnesses have been examined, you should have supplied the copy.
I have supplied.
Now, just now, he's
additional deposition copy
deposition copy. And then I'll pass it over, just read it.
Yes, sir.
Pass it over, just, if possible. Yes. 24, yes.
Then on the last occasion it was there. The case under section 302, because the trial is going on. Out of 25 charge sheeted witness, 13 already examined. I, in the meantime, filed an application under section 311 CRTC, seeking to
recall 1, 2, 3, and 10.
1, 2, 3, and 10. That evidence copy was not there on the last occasion. That's why it was adjourned to today.
Yes.
So, Lordship, kindly see. And only for limited purpose, only 2-3 questions I have to put. I have stated categorically in my petition what are the questions I want.
Why have you not filed all these things?
Well, it was not there. Today morning I got. I am extremely sorry. I will not do.
See, no, but it has to come on record. Otherwise, how will I rely upon this?
I was hearing in other case. Today morning I got it.
Then place it on record and just see it.
Your Lordship, just tomorrow.
Not tomorrow. Next week. Mr. Vishal and counsel for the petitioner.
Permit me.
What to do? You should have done it. I can't rely upon a document which is not there on record. Because these are, paperless court.
As your Lordship.
It has to come on record.
On Monday, your Lordship specific, because it was last occasion, your Lordship directed on Monday. But it could not come.
This was listed on 7th February.
7th February. Yes. The 7th February, your Lordship called this matter on Monday. But it has not come today.
We'll see. Yes. Next week. Yes.
Yes.
25.
Evidence of this.
25. How? Yes.
May I please, Your Honor?
Yes.
Sir, my lord, the petitioner is the informant. In a case, my lord, registered under section 3 of the SCST Act along with the allied offences of the IPC. The police submitted the charge sheet against the petitioner deleting that 3 SCST Act. Against that, my lord, the present petitioner filed a protest petition under Annex of 3, my lord.
Yes.
In the protest petition, my lord, he filed certain documents. And my lord, the accused belongs to Andhra Pradesh. And in Andhra Pradesh, my lord, that caste is, my lord, OBC. That's why, my lord, SCST is clearly applicable in the case. However, my lord, the Law and Session Judge, my lord, Special Judge, at the time of, my lord, taking cognizance, my lord, your Lordship kindly see page 49, that is 6/9/2024, my lord. Not taken the cognizance under section 3 of the SCST Act, only the cognizance.
Because OBC
is not applicable, only SCST, my lord. OBC is not applicable. So
that's what he says.
No, my lord. Here what happened, my lord, he filed a false certificate that he belongs to SC, my lord. By the state of Odisha, my lord.
Yes.
But he belongs to Andhra Pradesh, my lord. In Andhra Pradesh, my lord, that is OBC. OBC, my lord, does not include, my lord, in the provision of.
Yes.
So he is, my lord, clearly applicable. SCST is clearly applicable.
Show me that.
My lord. Your Lordship kindly see that. Page 40, my lord.
40.
My lord, 40.
Yes.
That is the Tahsildar Meliaputtu Mandal, my lord, given that he is, my lord, a BCA, Rajapur.
Yes.
That is the second para of that report, my lord.
Yes.
That caste verification.
Andhra Pradesh.
My lord, Andhra Pradesh, my lord. The Tahsildar of, my lord, Paralakhandi wrote a letter, my lord, to the, because the party belonged to Andhra Pradesh, my lord. The Andhra Pradesh, my lord, in the second para, your Lordship kindly see, who are belong to BCA, Rajaka by caste, and all are migrated to, and address are not raised, and there is no property in so.
Yes.
So, my lord, he is not a, my lord, he is not belongs to SCST, my lord. The accused. So, the act is very clear. Your Lordship kindly see my statement, my lord. My statement under Annex of 31. 31.
Page 31.
Sorry, my lord, page 31.
Yes.
There, my lord, I have categorically stated that they are abused, my lord, in filthy language touching my caste.
Sorry, where is that?
31.
Yes. Read it.
My lord. More namo.
Relevant part.
My lord. Relevant.
ସେମାନେ ମୋର ମାର୍ଲା ହରିଜନ ଜାତିକୁ ଆକ୍ଷେପ କରିବାରୁ ମୁଁ ସର୍ବସାଧାରଣ ସ୍ଥାନରେ ଅପମାନିତ ହେଲି ଓ ଜୀବନକୁ ମାରିଦେବାର ଧମକ ଦେଲେ ତେଣୁ ମୁଁ ଗୋରାଣ୍ଡି ଥାନା ରିପୋର୍ଟ ଦେଲି ବୋଲି ବିହିତ କାନ୍ଦିସନ ପାଏ that is the
this is the
notice. Yes.
I pray, my lord, for stay of that order, my lord.
1 minute. What will happen? If it will be added, it will be added. What is it?
My lord, because now all the offences are tribal law magistrate, special judge.
So that it will be transferred. If it is added. Yes, next.
26.
Yes.
I may please. This is a petition challenging the order passed by the learned court below, as because my petition under 311, that is 348 of the BNSS, which has been filed before the court, called for the doctor who examined the victim in a POCSO case, ma'am.
Doctor.
Miller?
PW 18.
No. That doctor has not been examined. I filed a petition. The doctor should be called upon to prove the reports are submitted. But the court.
Show me his evidence.
Pardon?
Show me his evidence.
Also, for evidence.
In
this case, victim has not been examined, refused to examine before the doctor. The said doctor is the doctor.
He want recall of that doctor.
No, not recall. To summons to give evidence before the court to as a witness, your lordship. He not been examined. But here is a case, the victim not been examined before her, that said doctor, lordship. There is no need of calling up for adduce evidence before the court, your lordship.
Where is his
That is
application?
impugned is annexure.
Where is his application?
Application is not there, but the evidence of all the witnesses which.
Let us see the application unless it's show me the. Why are you not filing application? I don't understand.
Problem is like this, Lord.
What problem you have drafted the petition without seeing the application?
On the date fixed for accused statement, the accused by inadvertently told that I don't want to.
I understand where is the application? What application you have moved before trial court?
That petition I have scribed there and filed there, so I could not obtain the copy. That is the whole problem. That's where the problem is.
And I need to know what are the application you moved, where this impugned order is passed. What was your prayer?
Page 10 may be seen, my lord, the impugned order, there everything has been clarified. The court has specifically written everything.
It says that you have moved an application under 311 CRPC.
Yes.
What is that application? What was the content?
I have filed the petition to call the doctor as a witness for the defense. Because in the very first instance, the victim has been examined, and that certificate report, which has been produced by the doctor, has not been approved by the prosecution on the ground that she denied to examine herself. And the evidence shows that only once she has been examined, and still that is not coming to the record. If the victim will be evidence is taken, she categorically stated she has only been once examined.
You just tell me what was your prayer in that application.
Prayer is to call the doctor who has examined the victim in the first instance.
That's what I'm asking. PW 18, you want to recall?
No. She has not been examined at all by the prosecution.
Doctor, you get that application. I don't know. What have you said?
The certified copy.
Yes, you do whatever. I need to know the application. What was the application? It's very difficult to connect.
Okay, I bring it. But then the matter is posted for argument.
Stay.
If it would not be stayed, then.
First of all, you file an incomplete petition. And you are not able to satisfy me. Second, you need a stay away.
It is not incomplete. But I have not obtained the copy.
You have to obtain because see, a application was moved to you. In the application, some order is passed. That order you are challenging. And the application is not there.
That's why
you file it next week. Yes. File it, get that application. Yes.
I'll file the certified copy immediately and going to file it.
Yes, next.
Interim order.
No question.
Otherwise, if the
let it be. If you file incomplete petition, what can I do?
If the
No, this practice is very bad. Yes.
27.
Yes, 27. Next week I am putting. Yes. What can I do? You just tell me. You get the application at least. I will pass it over and.
7 days time maybe.
No. I will pass it over. Get the application.
Yes, I will get it.
I just pass it over. Get the application. I will see.
Immediately, I cannot get it.
Then they face the consequence. Next. Yes.
7.
No. This is very, very, very unfortunate that almost all the petitions are being filed like this. This has been a regular practice here.
If I would have the copy.
Filing
When I have-
one page order, half a page of impure order quashing.
My lord,
How can I quash it?
on documents before the honorable.
Let us not waste
I should have
time.
filed that.
You get that, I will pass it over. Best thing I can do is I can pass over. You ask your briefing counsel to send it so that I can say.
She has categorically stated I have not been examined by the doctor.
Pass it over. Pass it over. Yes, next.
Involved in a vigilance case. During investigation, we filed.
I am passing it over. Yes, yes.
Annexed 2 series, also page 40.
Series?
Annexed 2 series, page 40.
What are you seeking here?
Here for a direction to consider the documents which I have filed before the IO during investigation. My limited.
Investigation is going on.
Yes.
What direction is required? It will be. Huh? He is seeking, he is relying upon certain document. He wants that it should be considered. That's all. In accordance with law. I can't direct. I just simply because I can't direct the investigating officer to do.
Let him consider.
I will give him liberty to place it before court and let it be.
Now already that has been sent through post and I have already received that document. All the documents he has already received.
In the present petition, petitioner is seeking. Petitioner is exploring the following relief. Prayer. The prayer is vague and no order is necessary to be passed. Mr. Moon, however, Mr. Moon, counsel for the petitioner submits that the documents placed before this court is annexed to series has already been supplied to the investigating officer. If such documents are submitted to the investigating officer, it is expected that the IO of the case shall deal with the document in accordance. Again, it is open for him to deal with the documents in accordance with law while filing the report under section report of the file form under section 173. Yes. I just come. Please, there is an indication. Okay. Yes. Yes, sir.
So this is a matter where we are seeking quashing of the PMLA proceeding initiated by DI. So far, the petitioners are concerned.
Yes.
So far, the only one petitioner. The grounds of quashing are three. One.
No, there are two petitioners.
There are two petitions because there are
company.
two cases.
The other one is a company.
Yeah. The grounds for quashing are threefold. One, the vigilance case in respect of the schedule offense and other offenses have been quashed by this court by an order dated 23/9/22. That is at page 90 and page page 63. It starts from page 63.
63.
Yes, if your lordship want to see, I can show it your lordship 63. It discussed. Then at page 90, if your lordship look at page 90.
Yes.
Para 18. In view of the well-settled principle of law.
Now, let us see the page 63 first. This is some other accused. Is not, that's what the objection was.
No.
Mohammad Sapruj. Mofajular
Rahman. He is dead, my lord. His name has been deleted from the prosecution.
Okay. Yes. 90.
Yeah.
Showing in 90. Yes.
Yes. This is Muzawaran and another petitioner. Both
Yes.
were petitioners.
Yes.
Petition number 2.
Yes.
And that is at page 90. The order is there.
Now, in that petition, you are a co-petitioner.
Co-petitioner. Well, they admit there is no dispute that the vigilance case so far.
No, but come to 63, it doesn't say another. It says only one petitioner. That's the problem.
In 63, my lord, only one petitioner. At page 92, your lordship kindly see page 90.
90, na?
92.
92.
92. Raw.
Let us be clear about it first.
Page 92.
92. Yes. Yes.
Here, there were two petitioners. My lord.
92. The other one.
There were two FIRs, two charge sheet, two schedule offense cases were registered.
In one schedule offense is quashed for all both the petitioner.
Yes.
And the other schedule offense is quashed qua one of them.
One.
No schedule offense against me. Nothing is existing. Nothing. And they admit in their counter affidavit.
Okay.
Lord, there are two affairs. I'll sort your loss. Two affairs where I have been along with my partner is been accused and of schedule offense. The allegation which I'll sort your lordship from the complaint itself that you have illegally mined is this illegality crime that you have committed. The crime property has come into the hands of the partnership firm, which is Sirajuddin and Company. That is the allegation, sum and substance. I'll sort your lordship. Now, my lord, before I proceed in detail, there are three grounds. One, the schedule offense vigilance case with regard to civil schedule offense, so far I am concerned, it is quashed by this order.
Yes.
Now,
by the order
of this honorable court.
Yes. That is page 63.
Page 63 and then
92.
another
92. Yes.
92.
Yes.
Number 2. In a similar matter regarding to mining operation, illegal mining, this court quashed the vigilance case.
Okay.
And the petitioner there went to the Supreme Court. Supreme Court, relying upon three-judge judgment of Bijam, quashed the PMLA.
So far as the COI.
So far, in other case,
Another.
Case, not that Indrani Patnaik, another case, mining operation, illegal mining. This court quashed it, entire charge sheet. Matter went to the Supreme Court, said no, once the schedule offense has gone, there cannot be a proceed of crime, that doesn't give you jurisdiction, it is all quashed.
Yes.
That is one similar matter I'm citing to a
Okay.
Third ground is the complaint itself. The complaint says the basis of filing this PMLA case is the two affair that has been registered.
Yeah.
And they say this is the foundation for registering the case. Therefore, if your lordship, before I proceed further, kindly look at the complaint itself.
Yes. Annexure 1. Yes.
Annexure 1, page 20. Start at page 20.
You are intikam alam.
Kindly look at the first paragraph. An investigation under PMLA was initiated by Enforcement Director Bhubaneswar Sub-Zonal Office Bhubaneswar against Sirajuddin and Company and others for alleged commission of offence under Section 3 of PMLA on the basis of the charge sheet number so-and-so and charge sheet number so-and-so, both filed in the Court of Special Judge Vigilance Baleshwar under Section 120B, 420, 379, 13.2, read with 13.1D of the Prevention of Corruption Act 1988,
yes.
21 of the MMRD Act, arising out of FIR 54 dated 18/11/2009 and FIR 55 of 19/11/2000, respectively registered at Vigilance PS Baleshwar, Odisha, relating to manganese ore mine at so-and-so iron ore mine in Barla, both situated in the district of Keonjhar, Odisha of Mrs. Sirajuddin Company. The said charge sheet reveal commission of punishable offence under section 13(2), read with 13(1)(d) of the Prevention of Corruption Act of 1988, section 201/379(420)(120)(b), section 21 of 1957, section 2 of the Indian Forest Conservation committed by Sirajuddin others. The offence punishable under section 420 and 120(b) of IPC are schedule offences as defined under section 2(1)(y) of the PMLA. The charges against them in the charge sheet 4 of so and so of Badla iron ore mine is that they had criminally conspired with themselves and caused wrongful loss to the government to the tune of rupees so and so, and owner committed theft of thereby derived pecuniary advantage. The charge against them in charge sheet number 3 dated 30th March 2012 is they had criminally conspired with themselves and caused wrongful loss to the government to the tune of rupees so and so, thereby derived pecuniary advantage to Mrs. Sirajuddin Company is a partnership firm having had so and so.
You are admittedly one of the partners of Siraj.
Yeah, no doubt. I'm the partner there.
Yes.
Now, then your lordship look at page 21.
Yes.
Brief 2. The complainant submits that the condition precedent to investigate the offence of money laundering by the complaint director of enforcement, either there should be an affair or a police report under section 173 of CRPC or a complaint in respect of schedule offences under PMLA. The PMLA 2002 is an act to prevent money laundering and to provide confiscation of property derived and obtained directly or indirectly from or involved in any process or activity connected with the proceed of crime, including its concealment, possession, acquisition, use, projecting, or claiming it to be untainted property. Since section 120(b)(1)(4)(20) IPC, section 13(2), read it 13(1)(d) of the Prevention of Corruption Act of the Schedule Act, being schedule offence under the Prevention of Money Laundering Act, hereinafter referred to, enquiries were initiated under PMLA.
Since the inquiry is initiated, therefore the PMLA is stepped.
Correct. Therefore, the substance of the allegation is, this is what the illegal mining, this is what the proceed of the crime, in whose hands? In the hands of the partnership. That is Sirajuddin.
In the hands of Sirajuddin, and you are the partner.
Partner. You have committed that.
Yes.
The question, then your lordship look at
yes,
page 22.
22, yes.
Yes. The last paragraph before the charges against them, that is me and Mujapul Rahman. Against them is they had entered into a criminal conspiracy among themselves, thereof caused wrongful loss to the government to the tune of rupees so and so, and mine owner committed theft of so and so and so. This is the charge, my lord. Now look at, please come to page 48.
Yes, 48.
This is the PMLA proceedings. Look at page 48.
Yes. Yes.
Now para 38. Investigation, findings from documents, information, statement as mentioned above from Garuda Mining Mills. Investigation under PMLA was initiated by Enforcement Director Bhubaneswar, Subzonal Office Bhubaneswar, under ECIR number so and so against Sirajuddin Company and others for alleged commission of offence under section 3 of the PMLA on the basis of FIR dated so and so, subsequently final form charge sheet number dated, and FIR number so and so, subsequently final form charge sheet number dated 30th to 12th, as relating Garuda mines and Badla iron ore mines, Sirajuddin, as aforesaid, charge sheet reveal commission of schedule offence under so and also offence under so and so. This is the substance of the allegation. Now turn to page 57.
So there are then long and short of the matter is there are two FIRs, FIR number 54 and FIR number 55.
Correct.
And the charge sheet in regard to 54 is charge sheet number 3 and charge sheet in 55 is charge sheet number 4.
Correct.
On that basis, the PMLA is stepped in.
Step in.
And now let us see the whether these two FIR has gone or not.
It has gone.
That's the long and short of matter. Let us come to
there is a point which I like to, because they have filed a count.
Yes.
In the count, I'll come to that before your lordship look at page 57, if your lordship don't mind.
57, yes.
Conclude that.
Yes.
Conclude.
57, yes.
Yes. In view of above, it was revealed that Sirajuddin Company has acquired proceeds of crime out of commission of schedule offense under PMLA and project the same as untainted investigation conducted on PMLA established that the said property represents the equivalent value of the proceed of crime as defined under so and so. Therefore, the above mentioned immovable properties are involved in the offense of money laundering as defined under section 3, were provisionally attached under the provisional attachment.
By one and all. Yes.
From the investigation and the offense, rather it clearly established Sirajuddin Company were responsible for the conduct of the farm committed on the offense of money laundering.
And represented by the you and the other partner. Yes, two partners.
Now they say, yes, the counter says, yes, the schedule offense has gone against these two. It's all right, no problem. But under section 70 of the PMLA Act, interestingly, that's the one of the counter.
Yes.
Section 70 of the PMLA Act, the offense by companies, which include, of course, partnership firm. It says, where a person committing a contravention of any of the provisions of this act or any rule or direction or order made thereunder is a company. Every person who at the time of contravention was committed was in charge of and was responsible for the company, for the conduct of the business of the company, as well as company, shall be deemed to be guilty of the contravention and shall liable to be proceeded against and punished accordingly. Provided nothing contained in this subsection shall render any such person liable to punishment if he proves that the contravention took place without his knowledge and he exercised due diligence, so and so.
Yes, I understand.
No, this is similar to 141 of the negotiable instrument, section 17.
Yes, Mr. Agrawal, under the aid of 70, can you proceed against the partnership firm even if the schedule offenses are quashed qua the partners individually?
Here, my lord.
That's the real question.
Yes.
And then they rely upon, my lord, they rely upon two Madras High Court judgment which has nothing to do with this case. One, I'll tell you, Lord, in substance, one Madras High Court judgment says the proceeding for FIR was quashed. Once the FIR was quashed, petitioner went and said, since the FIR is quashed, please quash the PMLA proceeding. The High Court said, no, FIR is quashed on the ground that the serious fraud investigation agency is investigating to the schedule offense. And you have been arrested, charge sheet has been filed. We cannot quash it. This is one case. Another Madras case says, Lord, FIR is quashed. In spite of the fact, as FIR is quashed, matter went to Supreme Court set aside it. Then the investigating agency filed a closure report in the vigilance case. Once the closure report is filed, they said, please quash the PMLA. Supreme Court said, okay, the PMLA case should go, but I'm giving you an opportunity. If the vigilance case is revived,
it will be revived.
It will be revived. Then, my lord, the ED filed a proceeding under 482. The question came up whether 482 is maintainable at the instance of the ED. State Advocate General opposed, saying it's the state's power. State has filed it. The High Court said nothing doing. It is all illegal. The closure report is illegal. So therefore, the PMLA was not done. That's the two judgments which my learned friend signed.
Okay.
And Vijay Madanlal, I like to refer to some paragraphs which directly deal with this issue.
The basis goes, everything goes. That's the.
Madam, kindly look at Vijay Madanlal, if your lordship allow me, purely this question was canvassed by Mr. Kapil Sibal as well as Mukul Rohde. I will show that paragraph. The counter is in that terms of that paragraph, and the Supreme Court said nothing doing.
This is the first principle.
The first principle, that's right. Don't go to the judgment.
Proceeds of crime, the crime goes.
That is why I made a chart. If your lordship don't mind, kindly look at what a chart I have made, a flow chart. Kindly look at, give the flow chart.
If the crime goes, where is the question?
I just 2 minutes, my lord, if your lordship.
Yes.
My lord, kindly look at. First is the schedule offense to be investigated by the jurisdictional police.
Yes.
If when the schedule offense is investigated that give rise to a proceed of crime as a result of the crime activity out of the schedule offense, and then ED say proceeds of crime, they will not look at the proceed of crime. They will look at the process and activity relating to the proceed of crime.
Right.
That's the right. You look at the activity and process, namely the use, possession, concealment, whether you are treating it as your own. That is why, my lord, Sirajuddin came into picture, the partnership, because it is in possession of the property.
Right.
That is how, my lord, this is how, and this part, these two are independent of each other.
Yes.
Nothing to do with these two. These two are, this investigating by the jurisdictional police, investigation completely different. This is a standalone process. This is completely investigated by them. Nothing to do with these two. The only link is this proceed of crime.
What are the judgment?
If your lordship look at the judgment, I have. The first is, my lord, if your lordship look at the judgment which is this mining matter where only look at page 130 of my paper.
130.
Yes.
Yes. Yes.
This is my lord
Indrani Patnaik where you
Correct.
take that here.
And they just don't do anything. They say they quoted their 3-judge bench judgment.
Yes.
And then they say London Senior Counsel submitted the present case prosecution of the petition in relation to the.
Let us see Vijay Madanlal.
Yes, Vijay Madanlal, I have given your lordship a paper book like this. If your lordship.
Paragraph, just note it down and give you.
Can I give the paragraph?
Yes. Note down there, huh? Note down the para numbers.
Yes.
Highlight those para numbers.
Well, this I must tell your lordship.
Your entire case is Vijay Madanlal.
Vijay Madanlal,
yes,
squarely covers. I can understand. Another ground they are taking that, see, I was roped in under the 13.2 and 13.1D and all. Officers, government officers were roped in. Mine is quashed. 13.2 goes, 13.1D goes, 120B, conspiracy, everything goes. They are pending because they have retired. Nothing, vigilance case is there, nobody is in. They have not initiated PMLA because in their hands there is no proceed of crime. If there is a proceed of crime, they investigate. This is one of the grounds. See, the schedule offences are pending against them, but there is no PMLA against them, and you are not related to this, to the proceed of the crime in the hands of.
It might be pending co-accused, but insofar as you are concerned, it is qua.
Correct.
That's what your case.
Correct.
Yes.
Lord, originally, there are 6 partners of the firm. Originally, the complaint was filed against the company and 2 partners.
Including the present petition.
Not including present. Inka Balam, petitioner number 1. Now the petitioner number 2 is represented through Siraj Unsa Milord.
Through?
Petitioner number 2 company.
Yes, sir.
Is represented through Siraj Unsa.
Siraj, yes.
Originally, the complaint was filed against the firm Sirajuddin Company represented through its partner, Mofazulur Rahman, who is dead, his name has been deleted. He was also accused number 2 in his individual capacity.
Okay.
And accused number 3, Intiqam Alam, who is here petitioner number 1.
Yes.
Against original accused 2 and 3, schedule offense has been quashed.
2 and 3.
Yes, my lord.
Yes.
2 and 3, there is not, your lordship will get this. Kindly, this is the order sheet of that.
You come to page 18. Page
I
18.
come, my lord, I come.
No, page 18, all the names are there. Therefore,
Page 18.
yes. 18 and 19. 18 and 19.
18, 19, I have seen, my lord. That I will clarify.
Yes.
Your lordship, kindly see this order sheet. This is the PMLA proceeding order sheet.
Yes.
Originally, PC was filed against 3 persons, the partnership firm and Muzaffar Rahman and Intiqam Alam.
Yes.
Muzaffar is dead. His name has been deleted. And here petitioner number is, who is the petitioner number 3 in the PMLA proceeding. Subsequently, my lord, supplementary complaint has also been, I have folded that page also. Supplementary complaint has been also been filed.
And
adding all other part, because the proceeds of crime has gone to other partners' hands also.
Okay. Then you added 4, 5.
Yes, my lord.
Yes.
So schedule offense has been quashed against a dead man at page 63, your lord, and at page 92 against petitioner number 1. In the present 482 application, that schedule PMLA accused number 3, Intiqam Alam.
No, the 92, if you come to 92.
Yes, my lord.
Insofar as 63 is concerned, it is against the dead person.
Dead person.
You say. Who was
Already deleted,
representing the
originally.
And come to 93 now.
93 also, the dead person and Intiqam Alam, who is the
petitioner here.
Petitioner number 1 here.
1 here. Yes.
Against all other accused, now the PMLA proceeding is going on.
Yes.
Here, your lordship knows there are 2 types of accused in the PMLA.
Then you are the first. Let us test the first one. Then, insofar as petitioner number 1 is concerned, the PMLA doesn't lie, according to you.
PMLA, my lord, PMLA process that up to my lords. I will say.
No, that you have to tell me.
I submit, my lord. Schedule offense and the PMLA proceeding are 2 separate and independent offense.
No, insofar as petitioner number 1 is concerned.
Schedule offense has been quashed.
Then I'll allow insofar as petitioner number 1 is concerned. First of all,
yes,
keep that aside. Thereafter, let us proceed.
Thereafter, my lord, petitioner number 2.
That is the form.
That is the form now represented through Siraj Usa. That no schedule offense has not been quashed. There is no schedule offense, I think, subject to correction by my senior. Because I don't have that.
Against the other partners, there is no schedule offense at all. Vigilance case is not there. They have just, can you get PMLA?
I understand it, and they have added the supplementary charge sheet.
Yeah.
In the PMLA.
In the absence of
Your lordship kindly
vigilance.
section 3 of the PMLA Act. Your lordship kindly see section 3 PMLA Act.
Yes, then look at section 3. That's most important.
So by the way, when you added these people, let us understand.
That order sheet, entire order sheet are given, my lord. We have added him.
Why have you added them?
8, 9, 20, because my lord, investigation was open.
No, let us see the date.
Yes, 8, 9, 2023.
8, 9?
2023. I have given the order sheet, my lord.
8, 9, 2023.
3.
8, 9, 2023.
22 is cost. In 22 it was cost.
8, 9, 23 we have added, my lord.
There is no schedule offense.
Your lordship.
Now you can't sustain PMLA qua the form. So after quashing you added them.
In all those cases where schedule offense, that entire FIR was quashed. Here entire FIR has not been quashed.
Okay, that's let us see.
Here, my lord, entire FIR has not been quashed. In all those cases, entire FIR has been quashed.
Okay, when that FIR, who are the...
Let us see the what is quashed then.
Here, my lord, only with respect to your lordship, kindly see page 92 starts, that ends at...
Goes up till 121.
121.
121.
120.
In view of all.
120, result, and impugned order passed in TR in the Court of Learned Special Judge Vigilance, qua the petitioners,
Legally not sustainable.
only petitioners, my lord. This is the distinction, my lord. Now, your lordship.
Petitioner means petitioner number 1 and the dead person.
Correct.
Petitioner number 1 and dead person.
Dead person.
Your lordship kindly see.
No, now just answer the question. The partnership form was represented by 2 of the accused, okay? And one of them had died.
In the schedule offense.
Against one of them, now it is quashed. Now you want to go ahead with PMLA insofar as the partnership form is
because
concerned.
the proceeds
by adding 2 more partners. Against whom there is no schedule offense at all.
Because the proceeds of crime has gone in their hands. They are the beneficiary. Your lordship kindly see section 44.
44. And that you have done very tactfully after the schedule offense are passed.
It's not tactfully, my lord. The investigation was open. We found there are
Now you are supposed to do.
They are in possession of the proceeds
There
of
is
crime.
nothing wrong in doing
your
it
lordship
tactfully. You have to do tactfully.
First, my lordship,
That's your job.
Section 3 first, your lordship.
Let us see section 3.
Section 3.
Yes.
Whosoever directly or indirectly.
Yes.
Your lordship.
Yes.
Section 3. Whosoever directly or indirectly attempts to indulge or knowingly assist or knowingly is a party or is actually involved in its process or activity connected with the proceeds of crime, including its concealment, possession, acquisition or use, and projecting or claiming it as untenanted property. So here, my lord, the proceeds of crime acquired by the Sibo and Company firm had gone to other partners. Investigation was carried and it was found that the proceeds of crime has gone to in their hands.
Yes.
So they were added as accused. Now your lordship
kindly look at the definition of proceed of crime. Because Madan Lal has discussed everything.
Sir, you have completed and let me complete or you complete, then I will submit.
Okay.
No. Let you first submit, then I.
No, he will give the rejoinder. You just conclude it as quick as possible.
Yes, my lord.
Yes.
No, these are, I am just placing the provisions, my lord.
Section 3.
My senior said, explain. Your lordship kindly also read also explanation also.
Section 3, okay.
I was trying to shortcut. My senior wants let it go little.
No. Go ahead.
Yes.
For the removal of doubts, it is hereby clarified that a person shall be guilty of offense of money laundering if such person is found to have directly or indirectly, I stress here, my lord, indirectly.
Yes.
Attempted to indulge or knowingly assisted or knowingly is a party or is actually involved in one or more of the following process or activities connected with the proceeds of crime, namely concealment, possession, acquisition, use, or projecting as untenanted property, claiming as untenanted property in any manner whatsoever.
Yes.
The process or activity connected with the process of crime is a continuing activity and continues till such a time a person is directly or indirectly enjoying the proceeds of crime by its concealment or possession or acquisition or use or projecting it as untenanted property or claiming it as untenanted property in any manner whatsoever. Now, your lordship kindly see section 44.
44.
Yes, ma'am.
There.
At page 33, I think.
Yes, I'm there.
Explanation below.
Yes. The jurisdiction of the special court.
The jurisdiction of special court, while dealing with the offence under this act during investigation, inquiry, or trial, under this act shall not be dependent upon any orders passed in respect of schedule offence.
Yes.
And the trial of both sets of offence by the same court shall not be constituted as joint trial. So this is the answer, my lord. Even if schedule offence is passed, if a person in possession of a proceeds of crime, the PMLA proceeding has to continue. Your lordship knows there are judgments. Honorable apex court said there are 2 types of accused, my lord. One who has actually committed the schedule offence other where he has parked the proceeds of crime. Suppose I took the 10 lakh rupees for
No, under section 3, if you say, you are saying that irrespective of the fact that there is no scheduled crime or scheduled offense or not, if the proceeds of the crime goes to the hand, then the
then also the
PMLA goes on.
proceeding will
But
continue.
once you invoke scheduled offense against X or Y, if the scheduled offense goes, the PMLA goes.
Yes.
So
Yes.
therefore, what long and short of the matter is, what you say, insofar as petition number 1 is concerned, since scheduled offense is quashed, you leave it to the court now. Leave it to the court. And
My humble
insofar as the other
Yes, ma'am.
added accused persons are concerned,
Entire proceeding cannot be quashed.
cannot be quashed. That's what your case is.
My entire proceeding cannot be quashed.
Yes.
Here, your lordship.
Yes.
I just cite
Yes. 70 also you use it.
ଦେଇଦେବେ ସାର୍ କୋର୍ଟ ମୁଁ ଦେଇଦେବି ସାର୍ ଘରେ କପି ନେଇ ଲାଗ ସେ ଯୋଉ ପି ରାଜେନ୍ଦ୍ର ମୋ କାଉଣ୍ଟର ଯୋଉଟା କହୁଥିଲା
Yes.
This is the judgment by Madras High Court, my lord. The lordship kindly see paragraph 2 first.
Yes.
At the outset, it may be necessary to state that in a prosecution under the Prevention of Money Laundering Act 2002, there will be invariably be two sets of accused. One in the predicate offense and other in the prosecution launched by the enforcement director.
That's not a precise thing. But once there is a predicating offense against a particular accused, if it is quashed, he is inevitably.
There is also distinction. Suppose, my lord, I'll place that Madanlal judgment paragraph, some paragraph, my lord. Suppose schedule offense is quashed under technical grounds. While quashing the schedule offense in Vijay Madanlal Apex Court has specifically said, while quashing the schedule offense, the court is to give a finding that the property acquired is not proceeds of crime. Suppose in technical ground schedule offense,
Yes.
so it cannot be. Here also the similar things will on. It's not that on merit it has, on technical ground it has been quashed. By the direction of the Honorable Apex Court, your lordship knows that in coal scam case,
Yes.
ED investigation was carried out, my lord. And on the basis of that, PMLA investigation was carried and complaint was filed. Your lordship, just operating part of that judgment, my lord may see.
By the way, page 63 and 92 has attained finality. Have you challenged it?
No, we have not challenged it. We have not challenged it.
And there is a good reason why they didn't challenge. I'll show from the record.
62, my lord, that petitioner is dead. His name has been deleted. 63, page 60. That we have not challenged. That man has already dead.
What about 92?
92 against one part, we have not challenged. My lord. We have not challenged.
Yes.
Then, your lordship may this is the judgment by Allahabad High Court, my lord. Mohanlal Rathi versus Union of India.
Yes.
Paragraph 2, my lord. By means of this application filed under section 482 CRPC, the applicant has sought to assail the validity of cognizance summoning order dated so and so, passed in complaint case number so and so, titled Directorate of Enforcement versus so and so in the Court of Sessions Judge, Special Judge, PMLA, Lucknow, summoning the applicant for trial of offence under section 3(4) of prevention of and all proceedings of offence. Now your lordship may turn to paragraph 6. 456.
Yes.
The CBI, after investigation, submitted a charge sheet dated so and so against 11 persons, including the applicant. It is stated in the charge sheet that so and so, they have stated, not the fact. So, lordship may state, come to paragraph 6.
Yes.
On an application filed by the applicant, the Special Judge Prevention of Corruption Act, CBI Ghaziabad, has passed an order in special case number so and so, whereby the applicant has been made an approver and he has been granted pardon in the aforesaid case arising out of so and so. So he moved an application as because I have been pardoned by the schedule offense, so quash PMLA proceeding against me. Now your lordship may turn to paragraph 10.
Yes. Come to para 24.
Just time.
No, come to para 24. Your argument is here. Para 24, next page. Para 24, Madanlal is reproduced.
Yes, no,
and second part of the Madanlal.
Para 23 and para 24, Vijay Madanlal has been quoted.
No, next, para 24, next page.
Yes, Milord.
Yes, Vijay Madanlal 253 is reproduced. And now 269. 269, read it. Madanlal.
From the bare language of Section 3 of 2002 Act, it is amply clear that the offence of money laundering is an independent offence regarding the process or activity connected with the proceeds of crime which had been derived or obtained as a result of criminal activity relating to or in relation.
That's what your case.
That is my. Your lordship may kindly see para 57, the conclusion, my lord.
Yes.
Para first, your lordship, para 50, before that.
Yes.
An order for discharge. Your lordship got it?
Yes.
An order for discharge of the accused is passed for criminal proceedings against him are quashed when on the face of the allegation no tribal offence is made out against the accused person and an order of acquittal is passed when the accused could not be proved guilty even after facing the trial. On the other hand, pardon is granted to a person who is supposed to have been directly or indirectly concerned in privy to an offence. Pardon is granted only to a person who is involved in commission of the offence and not to a person against whom no case is made out or no case could be established. Then your lordship may paragraph 7. The power under section 482 CRPC can be exercised to secure the ends of justice as held in the state of Haryana versus Bhajanlal, a leading case, my lord, wherein the Honorable Supreme Court gave a word of caution by stating that the power of quashing a criminal proceeding should be exercised very sparingly and with circumspection, and that too in the rarest of rare cases.
Yes.
In case the contention put forth by the learned counsel for the applicant is accepted, it would result in a person accused of committing an offence under PMLA going scot-free without facing trial and without seeking pardon in PMLA case by making a full and true disclosure of the whole of the circumstances within his knowledge relative to the offence, and it would defeat the ends of justice.
Yes.
In view of the foregoing, the High Court rejected the contentions, my lord. Then, my lord, this is the judgment by Honorable Apex Court, my lord. I just placed 2 paragraph, my lord. Paragraph 2.
Yes.
The present appeals call in question the correctness of the judgment of the High Court of Delhi at New Delhi dated so-and-so in read petition criminal number so-and-so. These proceedings in the High Court in turn challenge the order on charge dated so-and-so as well as the charges framed on so-and-so by the Special Judge Delhi. While the charge against the appellant Punni Sabhrewal was under section 109 IPC, read with section 13(1)(e) and 13(2) of PC Act, the charge against appellant R.C. Sabhrewal was under section 13(1)(e) read with 13(2) of the Prevention of Corruption Act. In substance, the charge was the appellant R.C. Sabhrewal owned assets disproportionate to known source of income, and the appellant Punit Sabhrewal, son of R.C., has abetted him in commission of the said offence. Now your lordship may state on paragraph 7.
Yes.
All the judgments have been quoted, my lord. After the order of...
What are you trying to draw out of it?
My lord, I am trying to draw here, my lord. If a person in possession of a proceeds of crime, the PMLA proceedings will continue. It's a separate and independent offense.
They have distinguished Radhesham Kejriwal, that's all.
Yes.
Yes.
And this judgment was also cited by my senior state, assistant director versus state.
That your counter says, I have.
No
compilation.
counter. Compilation.
I have given the compilation. Whatever you have given in the counter.
Your this judgment is also called the compilation case.
Compilation.
At page 29 of my senior's compilation below. Assistant director versus state.
Hey, you are trying to converse what?
Milord, I am trying here, Milord, the entire PMLA proceeding cannot be quashed.
That I understood it. Entire
PMLA.
But this Puneet Sabharwal will not really help because it only says that the
regarding charge.
Radhesham Kejriwal is distinguished. That's all.
Yes.
They say that it's not applicable. This is going,
Only your lordship can just see this my senior's compilation also at page
29.
29. Yeah, I have a this is under PMLA, Milord.
Yes.
Yes.
Paragraph 62.
Yes,
Last
62.
page, paragraph 62. Last bit one.
Yes.
The chronological event of the litigation would reveal that a systematic approach was made by the accused person to escape from the clutches of PMLA proceeding. Once the proceeds of crime is staged out by the enforcement directorate and a complaint under PMLA has been filed before the competent court, the offense under PMLA has become standalone offense.
That is again section 3.
Section 3.
Section 3. That's not, there is no quarrel on that.
Now your lordship kindly see the Vijay Madan Lal judgment.
Yes. When does Vijay Madan Lal say that even if it is quashed, the court has to give an observation?
Since my land
that is not proceeds of crime and all.
I'll place, Milord.
Where is
entire
that?
Vijay Madan Lal relevant para I'll place.
Highlight and give it. Highlight and give it. Okay. Highlight and give it. Give it.
Allow some. Just I'll briefly I'll place some paragraph. Let my senior wants to complete. Let him. I'll just place.
You tell me the paragraph. You highlight.
Yes.
The paragraph and give. I'll read it. I understand it now.
Yes, Milord.
Yes.
My lord, I will give the my lord. I'll tell your lordship. Vijay Madan Lal was not deciding any case. It was a case where 13 amendment, 2013 amendment and 2015, 2019 amendment to the PMLA Act was challenged in different high court.
Yes.
If your lordship look at the first judgment,
They called all the petitions.
all the transfer petition, SLP, writ petition together there. And in the first paragraph, they say we are not deciding anything. We are just interpreting the provisions of the Act. And while dealing with, they have, my lord, there are several issues like the bail conditions, which was Justice Nariman judgment was overruled.
All provisions were examined.
Provisions were. So far, section 3 is concerned, they have dealt with that. If your lordship allow me 2 minutes, I will decide, refer to those paragraphs.
Tell me the paragraph.
Kindly turn to my paper book at page 104.
Where is the paper book?
Just turn to 104.
Huh? Scan wala. You had hard copy.
Yes, Milord.
Compilation. Give it. Your compilation is thicker than the.
There are all 3 judgments and the Madan Lal was really only.
Yes. Page
104, my lord. It starts with the preface.
Sometimes it is very scary. Looking at this.
I was always say, who has read the judgment of TMA Pipe fully?
I don't think anybody. Nobody will pick up paragraphs at
6 different
at least 3 to 4 times I have read only second volume. No? There are 2 volumes.
Even Kesavanand Bharati, who has read it, is a full.
This judgment, my lord, I have read at least 2
volume 73 1 SEC. That's all.
Entire volume.
Entire volume.
Who read it? And once, my lord, in one judgment that Parliament vote to be who will have
the problem is
case.
The problem is that side you pick up your convenient paragraph. And both the sides pick up convenient paragraph. When it comes to this side, along with both the paragraph, the court has to see other paragraphs also.
I have made 2 volumes.
In the lighter side, I must say that your lordship have chosen that.
I have made it 2 volumes.
Nothing to creep about.
And volume 2.
And so the relevant paragraph.
Which page?
Page 104.
104. Yes.
That is what the court says. In the present batch of petitions appeal cases, we are called upon to deal with the pleas concerning validity, interpretation of certain provisions of the prevention of molestation and the procedure followed by the enforcement director while inquiring into an investigating officer under PMLA being violative of the constitutional mandate.
Yes.
Now turn to page 107.
Yes.
This is the submissions of Kapil Sibal, which is narrated. I am not concerned with anything else. Kindly turn to page 111, Miller. Number 4.
111. Yes.
Number 4. Mr. Sibal, while referring to the definition of money laundering under section 3 of the PMLA, submitted that the ED must satisfy itself the proceeds of crime have been projected as an untainted property for the registration of an ECR or an application of PMLA. It has been vehemently argued that the offense of money laundering requires the proceed of crime to be mandatorily projected or claimed as untainted property. Of proceed of crime, such proceed being projected or claimed as untainted property, it is stated that the pertinent condition and projecting or claiming cannot be outstayed and may be interpreted to be or by the explanation which has been sought to brought by an amendment made in so and so. Now, Miller, kindly turn to page 116, straight 116.
Yes.
However, by amendment of in 2013, the words trial for any schedule offense were replaced by the word trial of an offense under this act. It is urged that for the property to qualify as a proceed of crime, it must be connected in some way with the activity relating to the schedule offense. Meaning thereby, if there is no schedule offense, there can be no property derived directly or indirectly.
Yes.
Thus, this is the argument. Kindly look at
the entire conspectus is if there is no crime, there is no proceeds of crime.
Once there is no proceed, that's the land on which you build up your superstructure.
So that is the whole idea of
the the structure.
So therefore the schedule offense goes, the crime goes. So where there is no proceeds of crime. That's
no proceed of crime. Where is the schedule offense? It has gone.
So the distinction is section 3 says, distinction is if proceeded, if you are prosecuted for schedule offense and it is quash, then you are out. If you are not prosecuted for schedule offense, even then PMLA goes.
Because
then there is more danger.
Yes, there must be a schedule offense. Maybe against A there is a schedule offense. There is a proceed of crime. The proceed of crime has gone to the hands of B and C. B and C can be roped in because the proceed of crime is to be there.
There should be a crime.
There should be a crime. Without a crime, there cannot be a proceed of crime.
This is the whole judgment.
My learned friend read it. Please turn to 147.
147 now.
Please turn to 147.
Yes.
This is what it is argued, my lord. Specifically what he argued now.
That is 147.
147 para 5.
Mr. Rodriguez.
Next argued on behalf of the... He argued that the explanation to section 44, which he cited, is contrary to section 3, read with section 2(1)(u). And
what is the answer to this?
Answer is it is a different proceedings. But if the crime goes, the proceeds of the crime goes, and everything goes.
Where is the answer to this?
Kindly turn that answer. Consideration start at page 313, 314.
314.
Or kindly turn to state. My lord, discussion is there. But to shortcut your time, I will give those paragraphs. 615. Kindly turn to 615. To shortcut the 615.
Yes.
But this is the conclusion which they have drawn, their lordships. kindly turn to 616, 5A.
Yes, 615.
What is it covers? 616, my lord.
Yes.
5A. Section 3 of the 2002 Act has a wider reach and captures every process and activity, direct or indirect, dealing with the proceed of crime. It's not dealing with the proceed of crime. Any process and activity, direct or indirect, dealing with the proceed of crime, and is not limited to the happening of the final act of integration of tainted property in the formal economy. The explanation inserted in BioF does not expand the purport of section 3, but is only clarificatory in nature, which I read the explanation. Now look at D, my lord.
Yes.
The offense under section 3 of 2002 is dependent on the illegal gain of property as a result of criminal activity relating to the schedule offense. It is concerning the process and activity connected with such property which constitute the offense of money laundering. The authorities under 2002 Act cannot prosecute any person on notional basis or on the assumption that a schedule offense has been committed unless it is so registered with the jurisdictional police and pending inquiry trial, including by way of criminal complaint before the competent forum. If the person is finally discharged, acquitted of the schedule offense, or the criminal case against him is quashed by the court of competent, there can be no offense of money
But this judgment doesn't deal with the situation where if the schedule offense squad, the other accused persons are going on. What will happen to that?
But there is, I tell you, Lordship, so far other partners are come, there is no schedule offenses. There is no vigilance case.
Independent of proceeding against them under PMLA, suppose 5 accused persons are there.
5, let us say, my lord.
And against one schedule offense is quashed.
Correct.
Against the second, the PMLA proceeding is going on. And
without a schedule offense.
Without the schedule offense.
That is where it will go. I tell you so why.
That's the space.
I tell you why.
Yes.
Look at the definition itself. Look at the definition itself.
I think you have to delve open now section 70. How to get out of section 70?
70.
70.
70. I'll tell you.
Then can I put it? One more hearing is required.
Okay.
One more hearing. Because there is facts are completely misconstrued.
Then, my lord, can I read the, because your lordship have to deal with the reasoning which has been given. This is the conclusion.
Therefore, I think another half an hour.
Okay.
You tell me the date now. When can I put it? Short date so that continuity remains. And along with this sleep.
When we have 19 next Wednesday.
19th, this 19th will do. 19th. No, let it be 21st. 21st will not.
21st.
Friday.
First week, huh?
21st, I don't know. Very difficult now to say.
Then let it be 19th.
21st, your lordship is sitting in the DV.
Yes, I have a DV.
DV. So therefore, your lordship may have it on 19th.
19th. Okay. 19th.
At 12 minutes.
Not to, don't make it 12. Because see, everybody is getting.
After lunch, my lord, of election matters, otherwise your lordship knows.
I'll make it 3:30 because I'll take only half an hour.
Yes.
Nothing.
Yes.
3:30 so that other people will not
Yes,
get
that's
you know.
right. That will be open.
Because in between, if you take hearing matters, then
that's a problem for the other.
everybody.
Agree.
Your lordship, keep it, let it be there. We will make a.
3:30, he has to address on
no problem.
17.
I have to also place some.
And
paragraphs of the
please come
petition.
with the written submission so that
Written submission, let it be completed, we will give below.
Yes. No, if you come with it, it is to think that it is completed.
Yes.
Come with written submission so that along with written submission, I can
Yes.
proceed.
Yes.
It will be easier for me to, write the, yes.
Correct.
19th. Heading part. Huh? 58 withdraw. Okay.
Want to make a mention, my lord. Sorry, I'm extremely sorry.
Yes,
Pardon
what
to
is
make
it?
a mention, my lord. Weekly list item 98. Sorry, my lord. Sorry, my lord. Weekly list 98, my lord.
Not to give false evidence. It is sent to the court where the offense is tried.
Okay.
That
Non-appeals for the petitioner even on second call, in the interest of justice schedule. Yes, next.
18. The order of cognizance,
Yes.
the ground of compromise, your lordships. The offense is 376(1), and the present petitioner is the sole accused.
Sorry?
The present
Use the
petitioner,
mic.
the present petitioner is the sole accused.
Yes.
And other two accused, one is on bail, and another is the present petitioner already married.
You have settled the dispute and they are married.
Lordship.
That's what you.
Lordship.
Three petition, against three accused persons, evidence has been taken. And petition has been filed against one. In the
What about the other two accused?
Sir, one is on bail, and another issue against him.
See, the FIR cannot be quashed qua a one accused. Sorry? That those things, talk about law. Logistic problem is coming in the Koraput, there is a problem in traveling and all. These are not, that is not the concern of the court. Legally, if it is permissible, it will be done. You may have some personal problems. There are three accused. Offenses are 376 and 34.
376, 36.
506, 109, all offenses are there. Can you settle the dispute qua only one accused? Got it. That's the question. That's the question. You have to get over that objection.
Dispute something less dispute because
You bring other accused person, make them party. I am not advising you, but you whatever you want to do. Yes, you do whatever. I'm simply adjourning it. Okay, simply adjourn it, and don't tell your problems. Boss late higala, korauchi. Eguda korni. 482 jurisdiction rauni. Eguda. Boss midlani la what to do?
They have applied for marriage. That can be quiet, but see, the sahaja korchun semana iya bahi la ko aap pass
No, you can't do it because see, because the offences are such. You can't do it. Implead them as co-petitioners. And even if somebody is absconding, obviously he will abscond because of the offences are serious. And let him appear through VC and Quashing. Okay, you do it. How much time? One week after? Okay, after 1 week. Huh? First week of March. Huh? you implead both of them as co-petitioners and ask them to appear through VC. Okay.
23.
Yes. 420, yes.
And he has already received all the money and he has already removed the matter.
Yes.
Filed the joint affidavit marriage. And
Yes.
Also, in this case, total 3 accused persons there. So far, Deepak is concerned against him, the case has been split up. And the other 2 accused persons, Rupak Kumar Saw and Uma Saw, has been faced the trial. Out of 38 witnesses, 6 witnesses were examined. And out of 6, though they have supported the case, they have given the money to the accused persons, and also known to Deepak, who has not against whom the case is split up. And given 70,000 and 50,000 they have stated in the deposition also. In a total clock has given towards purchasing land in Bhubaneswar. In the 423 estate is concerned. If the amount has been received given by the accused person to the informant, there is an affidavit is filed by that.
Yes.
Yes, your
Where is the informant?
Informant was your lordship.
Sundar Minch.
Sundar Minch.
Well, just ask that. Petitioner number 1 is absconding.
No, man. Another accused person, Deepak, who is Deepak. So here is Deepak is also 1 year.
He is shown to be absconding in
yes,
the chart sheet.
Yes.
Okay. He asked him, madam, at the instance of opposite party number 2, the petitioner number 1 has been absconded. Therefore, the trial for him has been figured out. The petitioner number 2 and 3 have already facing the trial. Out of 30 witnesses,
38.
Out of 30 witnesses, 6 witnesses have been examined. The 6 witnesses, those who have been examined, are not the vital witnesses. The vital witnesses. Petitioners are when the matter stood thus, the petitioners have entered into a settlement with the opposite party number 2. And on the basis of the settlement term, the present petition has been filed. The petitioners, all the 3 petitioners, and the number 2 are present in the court in that part of the. And they have also filed what is the additional affidavit? What is they filed? They have filed 2 affidavits. 2 affidavits. 2 affidavits. They have filed 2 affidavits. 2 affidavits. The parties have filed a joint affidavit dated 31/1/2025 inter alia stating as under para 2 to 7. Para 2 to 7. The petitioner number 1 has also filed additional affidavit separately inter alia stating as under para 2 to 6. Para 2 to 6. From the settlement term, it appears that the disputed amount of 1,20,000 has already been paid by the petitioners to the informant. The informant who is present in the court on the from the court states that he is not willing to prosecute the petitioner anymore after receiving the disputed amount and the disputed amount. Mr. Mahabir, the counsel for the case submits that since the dispute is inter se parties and they have settled the dispute, filed the affidavit before this court, and the disputed amount has already been paid to the informant. There is no legal impediment in giving interference to intelligence in the present matter regarding that issue. You got the money, no?
Yes, yes, sir.
Yes. Yes.
26. They counted the region, they counted, but what are the?
Yes, sir. Have you got it?
Yeah.
Yes. What have you asked the prayer that you go through it? Please to allow the.
My prayer is
Past
to
litigation
Lord
direction, which is a month.
one doctor initially examined the victim. He has not been called upon by the court, or the reports he has submitted have not been.
You want to examine as a defense, yes.
My responsibility also, the victim may refuse to examine, therefore, this doctor who is my line from seniors filed the petition for to examine to give someone to this
Doctor.
Doctor, need not required also, because the said doctor is not treated to the present.
What are you going to ask him? See, the doctor has not examined the victim. So what are you going to ask him?
The point is, my lord, victim has herself stated that she was once been examined by the doctor.
Huh?
She was once been examined by the doctor.
Yes.
And this report has been categorically stated on 17th of September, she was examined by the doctor. And this doctor examined on 17th of September. So if she was once examined, how the medical report come into the record again in another day? As per PW 19, she was examined.
Let us see the PW 19.
Miller.
Yes. 19. Read it. Which part? Which part?
As per PW 19, the last IO.
Which part?
Page 19 at para 3.
Yes, yes. I cannot say what is done by us. I have received the report of official.
7th line, Miller. The medical report dated 17/9/19 of the victim is not marked at the exhibit, though the signature of the victim and mother of is marked at D and D2. On 17/9/19, victim refused for her medical examination for Dr. Mona Lisa Mahapatra, but her examination was conducted on 19 of 2019. So when the victim says she was once been examined, when the initial IO has stated.
Obviously, the first on 17th she refused, and so 19th she was examined by another doctor, that is Dr. Dipali Prusti. Yeah. What is wrong in it?
First IO who has examined, who has sent the victim to the medical, he has categorically stated that she has once been sent to the medical. Who did?
Yes, for examination only 19/1/2019.
If the victim has been sent to medical.
But she refused, then why should she go to medical?
That is the case.
That is very clear from this. What are you going to ask then?
She had been to the hospital.
See, on 17th, she refused to be examined. So she has not gone to hospital.
Yes.
So on 19th, she was examined by another doctor, that is Prusti.
But who sent?
That is the statement. Huh?
Who sent the victim to the hospital?
Oh, these things. Oh, no. You where is the questionnaires then? What are you going to ask this man who has done nothing in the entire?
That I have already brought from.
Then why are you bringing a person who is not at all in the picture?
Concerned about the matter case.
My point is, she had been to the.
What is the question you are going to ask? A person who has nothing to do with this.
I want to only examine that on 17th.
You can persuade him, bring him out. No, you can see Dr. Monisha Mahapatra has nothing to do with this case.
Yes.
She has not examined the victim, and I can understand if Dipali Prusti you want to call. I can understand because she has examined.
No, Dipali Prusti has already been examined.
Then
so I want to bring in.
Show me Dipali Prusti's evidence.
No, that evidence is not.
Have you put any sort of this question? And where is the suggestion you have put to the IO?
I have given suggestion to Dipali Prusti.
Where is that?
That the victim has not been examined by you on 19th, on the next day.
Where is that? Show me. Then now, see, that's the whole difficulty. And where is the question you put to the IO?
Yes.
Where is that? Show me.
PW 18 exhibit annexure 3.
Annexure?
Annexure 3.
Yes. Where is that suggestion?
Page 16.
16. 16. Yes.
At para 3 million.
For 3 years, very busy.
There I have approved and share Mr. Trade on 17th/9/19, third line, my lord. In para 3, third line, on 17/9/19 at about 9:20 a.m. The victim was sent to SC Medical College Hospital, Cuttack for a medical examination, accompanied by Women Constable Savita Jagdev. After examination of the victim, collected the biological samples of the victim and produced before me with the victim. If she was examined
Yes,
and the
then
biological
here's the
samples
case.
was collected,
But
Here's the
ninth,
case. No. Just see.
I will come to that.
And the IO says that on 17/9/2019, she was sent to ACB Medical College and medically examined.
That's
And who is examined? Prusti says that I examined in 19.
19th, your lordship. That
Then
lordship.
he's correct there. See, 17th, she was taken to hospital. And IO says that she was examined. What he wants to say is whether on 17th
or 19th.
19th Prusti is examined, that's not the problem. 17th, if she was taken, if the IO says that she was examined, very categorically she is examined, then Mona Lisa might have examined her. He wants to
Confront
bring him as a defensive witness. He is entitled, right? Petition is agreed by the order dated 30th/1/2024, whereby his application under section 311 CRPC for summoning one of the Dr. Mona Lisa Mahapatra, to be examined as examining on her defense has been rejected. Then counsel for the petitioner taking me to the evidence of the IO, that is PW 18, submits that the IO has very categorically stated in the cross examination that on 17/9/2019 at 9:25 a.m. the victim was sent to ACB Medical College, where she was medically examined. And the IO has also stated that the victim was accompanied by WC, namely Savita Jagdev. After the examination, he further stated that after examination of the victim, collected the biological sample of the victim and produced before me with the victim. It is also came on record that the victim was a second time examined on 19/9/2019 by one Dr. Prusti? Deepali Prusti. Therefore, the counsel for the petitioner submits that the victim, the examination of the victim by the doctor is doubtful. Hence, he wants to summon Dr. Mona Lisa Mahapatra, who is supposed to have examined the victim on 17/9/2029. The court below has rejected the application of the petitioner inter alia, stating as under page 20. Page 20, observing agent, page 19, 10, page 10. Mr. Mohanty, responsible for the state, vehemently oppose the prayer made by the petitioner on the ground that if the victim was not examined on 17/9/2019 by Dr. Mona Lisa Mahapatra, there is no occasion for him to be examined. And therefore, the application made by the petitioner is rightly rejected by the trial court. I peruse the evidence placed on record as well as the routine order. I want to review that the shadow of doubt being created by the prosecution witnesses regarding the examination of the victims, either on 17/9/2019 or on 19/9/2019, needs to be clarified. Therefore, the summoning of the witness, namely Dr. Mona Lisa Mahapatra,
Mona
Lisa Mahapatra by the accused to examine as a defense witness is justified. Accordingly, the application moved by the petitioner, whenever you move the application under section 311 CRPC on 30th January 2025, deserves merit, and accordingly the same is allowed. The trial court is directed to issue appropriate process to summon Dr. Mona Lisa Mahapatra for her examination as a defense witness by fixing a particular date. It is made clear that the petitioners shall not seek unnecessary adjournment, and conclude the cross-examination on the date to be fixed by the trial court. Yes.
Actually, it's Monisha Mahapatra. As per the application, it is Monisha Mahapatra.
Application you have written Mona
Yes,
Lisa?
Monisha. That should be.
Monisha Mahapatra. Yes.
28.
Yes.
And as the offenses under section 150, 341, 159, 283. The allegation that some persons were they block the road for opening of sugar mill.
What are the evidences collected by the police? So therefore, it's not necessary that the police is going to documents might have been filed. Statement of 150, statement of witnesses might be there. The object is filed, cognizance is taken. You might have got the entire copy. Everything you, I don't say all that. No, you might have got entire charge sheet copy. Don't say that. See, what is this? You file a petition. You don't want to satisfy the court, and the annexure will be filed by them. You will file the petition only. I can understand if you don't have a copy. I can understand. I can ask for it.
Copy of the statement.
No, you have to file an entire document to satisfy the court. Cognizance order at this stage, why should the court will interfere?
My lord, private case, if you see, there is no mention regarding that we have FIR in the other 143, and also under my charge sheet and cognizance taken 143. There is no mention regarding that I was among the.
For that, you have to see the statements of witnesses and all, then only you can form the conclusion. Now you argue on all these things at this stage, framing of that. I can't see this. How many
offenses you are justifiable?
See, I'll tell you. Cognizance is 1 minute. Cognizance is taken against as many as 18 people. 18 people. This petition is filed by only one, and role of all of them are same.
Role, what is the whether it is same?
Same, of course, same. I have seen it. Same.
And-
How can I quash it like this? It will have an impact on all the 18 people. And then thereafter you will come, I am covered. 18 petitions will be filed.
His name is the
Yes, and petitioner is agreed by the order dated. You challenge it. Petition is agreed by the order dated 12/2/2024. On May 12/2/2024, whereby apart from besides the petitioner, cognizance has been taken against as many as 18 persons, 17%. The cognizance for the offences punishable under section 143, 341, 283, 149 IPC again has been taken against the petitioner. All the accused persons were not arrested. Rather, the IO had issued notice to
Offences are
them
variable
under
in nature.
41A, 41(1)(a) for CRPC. Mrs. Jafrullah, counsel for the petitioner submits that the offences are available in nature, and there is no allegation as such made against the petitioner, against the petitioner. I have perused the charge sheet and the other document placed before placed along with the petition. It is found that the role ascribed to the present petitioner is same to that of the other accused person against whom the cognizance of the offences has been taken. Therefore, it is difficult at this stage to segregate the material placed by the police against the petitioner vis-a-vis the other accused person. In these circumstances, I am not inclined to entertain this petition at this stage. However, liberty is granted to the petitioner to move a specific application before the trial court for seeking discharge. If such application is moved, the same can be considered on merit on the basis of available material on record vis-a-vis the present petitioner. With this observation, the petition is disposed of. Next.
29. Very quickly on the fine amount is expected.
They may discharge all of them. Yes, next. Yes, sir.
May I please, madam? Order taking cognizance under challenge. Facts of the case is like this. The present petitioner was working as data entry operator. It is alleged that by forging the secret numbers, the petitioner has withdrawn sum of rupees, an amount of rupees 10,50,000, and from the account of the principal. The principal has sent one of the lecturer to verify from the bank, and from the bank it is ascertained that on suspicion factor that the present petitioner has some account has been gone to the account of the present petitioner. But the basic question is whether the college has appointed, governing body has appointed the present petitioner. Without sanction, the petitioner cannot be prosecuted. Number one thing. Number two, the cognizance order had annexed.
Is it your official functioning?
Not official function, but the another thing
you have withdrawn by employing this kind of method from somebody's account, and you want sanction for that to be prosecuted. First principle is whether it is coming under the color of duty or not. It's not coming under the color of duty, as simple as that. So no sanction is required. That point is gone. Next.
And the Annexure 3, page 29, shows that the learned STM has not applied his judicial mind before taking cognizance of the offences.
If these are I have told you, these are the formatting order. How can I can't go and ask him whether you applied judicial mind. Then if I start interfering in this, then I think all the cognizance order pass in Orissa will have to be quashed. Because there is a format
order and cognizance
not taken. But and all these things are being done by the back office staff.
Then,
And what the judges do is they write taken and sign.
sir,
This is the reality. You know that. Can that be a ground?
another thing, my
So
lord.
that is the reason I always say if you have a case, I relegate you to the trial court for moving an application. At the stage of charge, you can argue it. At least that stage, at least the court will apply the mind.
My lord, my
And
observe-
cognizance orders are, the law is, it's not the post office that you, once it is given, you take cognizance. That's the law. But the ground reality also you have to realize.
my lord, I observe that.
That's the problem. Right. Petitioner is agreed by the order dated 25.
Permitted to withdraw to raise all the points by filing discharge.
To that, whereby cognizance of offences punishable under section 420, 409 IPC, reduced section 66C of ITF has been taken against the petitioner. Mr. Pandal and counsel for the petitioner seeks to withdraw this petition to raise all the points before the trial court by moving the appropriate application
For discharge.
For discharge. If such application is moved, the same shall be considered on its merit on the basis of available material. To this observation, the petition is disposed. Yes, sir.
30, my lord, this is a peculiar case, my lord. Order taking cognizance is under challenge. No contract articles have been seized from the possession of the petitioner. Only basing upon the statement of the co-accused, the petitioner's implication.
Yes.
My lord.
Are you on bail or not?
Ma'am.
You simply tell that.
If my lord will grant
was, tell me what can be done.
My lord, if my lord
These persons are granted bail, you are absconding. You are absconding, yes.
The case of Kilo starts on safe footing. Present petitioners may.
You should give that. I'll try to find out.
Present petition has been disposed of with liberty. Case of Kilo has been granted bail. I am starts on safe footing. Case of Kilo has been disposed of later on. My present
Case of Kilo and
my present petition is Raju Hantar. Raju Hantar has moved in the year 2023. This honorable court bench has disposed of the granting liberty to dispose of on the same day. The present petition stands on.
Then you didn't go.
No,
You didn't go. Okay.
But that time,
That
the
time,
co-accused bail order was not there. The co-accused bail order was in the year 2024.
petitioner is seeking in this petition is sealing the order dated 27/2/2024, whereby cognizance of offence punishable under section 20B2C and 27 capital A of NDPS has been taken against him. Mr. Pandal and the counsel for the petitioner submits that except the statement of the co-accused, no other material is placed against by the police in the charge sheet to implicate the present petition. Therefore, on that ground, he seeks indulgence of this court for quashing of the cognizance of order. The petitioner has been shown as an absconder into charge sheet. Earlier, the petitioner approached this court by filing ABPL number 11353 of 2023. 23. The coordinate bench of this court by the order dated 11/10/2023 dispose of the anticipatory bail application, granting liberty to the petitioner to surrender before the court below and to move bail application, bail application, and the same was directed to be disposed of on the same day. The benefit of that, the petitioner has not availed the benefit of that order and remain as an absconder. In the meantime, one of the co-accused person, Sibo Sankar, has also approached this court by filing ABPL number 3679 of 2024. The coordinate bench of this court by the order dated 29/10/2024 has allowed the application of the said co-accused, relying upon the judgment of the Honorable Supreme Court in Tufan Singh versus State of Tamil Nadu. Reported in 2020, 80 OCR SC 640 641. Now, Mr. Vandal and counsel for the petitioner submits that he will not press this petition insofar as the challenge to the cognizance order is concerned. However, he submits that he would liberty may be granted to avail the benefit of the order dated 11/10/2023 pass in ABPL number 11353 of 2023 passed in his case in the earlier occasion. The praise made by Mr. Ponda seems to be innocent. Hence, I accede to the prayer and grant liberty to the petitioner to appear or surrender before the court on or before 15th of March 2025 and resort to the remedy available to him under law. It is open for the petitioner to take all the points while pressing for bail, including the ground of parity. Including the ground of parity, if such application is moved, the same shall be considered on the with this observation.
Okay.
Yes.
Yes. 31.
Yes, sir.
Petitioner's vehicle was seized. The level of the prevention of cruelty to animal. Apparently, from the FRE the petitioner, he was not present. One driver was present in the vehicle, and petitioner is the driver, is the owner of the vehicle. The entire column accused was apprehended spot is column accused number 1. Then the driver of
come to the order. 3,27,600.
Prior to that, this petitioner, he has already handed over the vehicle to already given the lease to, and the person prior to the occurrence, date of occurrence is under annexure 2.
Come to the point. You
now
the direction is you have deposit 3,27,600.
This direction that upon filing of the payment of this amount, your release application will be considered.
So I deposit 50%, it will be considered. Okay. That's the order I'm passing always. 50% deposit. Because see the cattle which have been seized is under the custody of a third party. Custody of a third party. It's not third party. Who will spend money on them? Who will spend? You tell me. You are smuggling.
That is your to appraise your lordship. What I am seeing.
Foundation judgment have you read? Foundation judgment have you read? My judgment.
All the case relating to the release of the cattle, the payment is to. So for the section 35 to rule, say rule 5, all are saying regarding while considering the release of the cattle, that you have to pay the cost. So for the bar, what I subject your lordship's.
The vehicle goes where from they'll collect money, and it was put to auction, and that money will be utilized. That's the law. That's the law. If you want to argue on detail, I'll issue notice. If you want to argue, I'll pass the order.
So unable to pay huge amount, the guardian.
So therefore, I'm saying 50% you pay and go and argue whatever want to do.
50%.
50% you pay and deposit 50%.
Because my order is that
Valuation of the vehicle you show me.
Valuation.
Valuation,
where is the valuation?
Valuation of the vehicle.
This is which vehicle is this?
Valuation.
Also, Gleland, your lordship, type of vehicle.
Valuation.
Also, Gleland.
We have valuation.
Valuation.
Which year make?
Invoice vehicle around 9,72,000 in the year 2023. Invoice cheaper. Ashok Leyland, this is invoice is there. Valuation invoice
9,72,000. It was purchased 23. New vehicle only 23.
23.
What do you say?
Sir, this all was back in December 2024, Your Worship. In the meantime, 2 months nearby going to last year, Your Worship. And another remaining what they want to Your Worship has 60 days and more than another. Insist for to deposit 65% also. 327,000 is awarded by the SDGM, Your Worship. In the meantime, 2 months elapsed. Another 60,000 add. Then 65% come with credit to deposit. Gadi owner they pay go to that.
Because already.
Okay, he's correct also. Deposit 2 lakhs. Okay. Petitioner is agreed by the order the. See, my judgment is also referred to Gogyan Foundation. Agreed by the order dated 24/12/2024, whereby his application for release of the vehicle has been. You are the accused.
Oh, I'm the owner of the.
You're not the. Petitioner is an accused along with the petitioner. Apart from the petitioner is the owner of the vehicle and is also accused in THD PS case number 443 of 2024, registered for alleged commission of offence punishable under section 11 A, B, and C of Prevention of Cruelty to Animal Act 1960. The trial court, while rejecting the application, has directed the petitioner to deposit 3,27,600 rupees. As a precondition for release of the vehicle. The counsel for the petitioner submits that the petitioner is financially crippled to meet the condition imposed by the trial court, hence he seeks indulgence of this court. Taking into consideration the facts in entirety, I am of the considered view that the petitioner shall deposit 2 lakh rupees 2 lakhs to begin with, and the trial court shall release the vehicle on additional condition being treated proper to be imposed apart from deposit of rupees 2 lakh. Rupees 2 lakh instead of rupees 3,27,600. Petition shall also furnish indemnity bond to indemnify the cost of the cattle. See, 150 rupees he has taken.
Yes, sir.
200 basically. In all the cases, 200. 200 per day. 150 is taken. They indemnify the cost of upkeeping of the cattle by Gogyan Foundation.
Gogyan account number.
Gogyan Foundation. Gogyan Foundation. And the trial court shall pass the appropriate order in that direction as well. Yes. Yes.
32.
Yes. Yes.
Because the old case and it was filed at the time of other argument my lord. These are the question.
Yes.
One chance you're also
You are the accuser. Offenses?
138.
22 lakhs the amount.
No, 32.
22 lakhs.
Lakhs thought.
I will also kindly turn to page 11, the impugned order.
When was this complaint petition was filed?
24.
This is argument
24 January 2025.
But I can't pass an ex parte order. You take out notice and next 21st. Take out.
Pray for an info.
Huh?
Tally open also.
Oh, no, I see 138 matter, I can't say.
I will file a petition.
No. You take out notice.
I will take out.
I am putting it on 21st. What
Sir,
else you need?
Tally ki portal, sir.
Take out dusty notice and sir, come tomorrow, day after. 138 matter, there is a complete ban.
I quite agree. With
Complete ban of
I
stay.
quite agree, my lord.
Yes.
I will file a petition, let him get on it and lots of call it.
No, I take out the notice day after tomorrow. You show me the proceeding that it is listed tomorrow. Show me the proceeding.
I know.
Show me the proceeding that is listed tomorrow or day after.
It was listed on.
Thereafter, what is the next
There is
step?
a My instruction was that if
You show me.
your lordship will grant me some time. Orally I will sir. I'll take instruction immediately.
When the date is there, I'll put one day before that.
Quite.
See, these are the matters. Just see the age of this complainant.
My lord,
70 years.
I am conscious of everything. but-
2014 matter.
Sir. I am taking instruction when the case is posted.
Yes.
The two matters, there are 122 lakhs, 125 lakhs.
There are two matters.
With
Connected.
connected.
One chance I was seeking for your lordship, you will grant me that.
Two matters. I'll do it, but one day I can give. But the problem is the ex parte I can't pass the.
I'll find out when.
So let it be day after. Let it be.
I'll petition and lordship may call it.
Tomorrow. Matter tomorrow. Come with the instruction. Yes.
33.
Day after tomorrow. Day after tomorrow.
Tomorrow, sir.
Day after.
No, sir, I will talk to the court master and.
If tomorrow matter is there, tomorrow, otherwise day after. Yes.
If next week I take out notice.
Yes.
May please, 33, my lord. Against the rejection of 311 petition.
Yes.
PW3 and 15. PW3 is the victim. This is a matter of POCSO.
The POCSO.
15 and 2
PW3 is the victim. PW15 is the IO, my lord.
IO,
my lord.
What are you going to ask?
Your lordship, my question, whether you have stated before the IO.
Where are you reading?
My lord, page number 12, your lordship. In the rejection order itself mentioned, the question to be put to the victim, whether you have stated before the IO in your 161 CRPC statement that the accused kept relationship with you as a husband and wife. My lord, in chief, my lord, the victim.
Show me your definition.
18, page number 18, your lordship. I stayed there for about 3 months and the accused kept relation with me as a husband and wife. No confrontation is there, my lord, in the cross-examination. Without confrontation, previous advocate Pochanande. Change of lawyers.
What do you want to ask?
My lord, the question, my lord. Whether you have stated before the IO 161 the jaha se question taku confront karna diyan.
Just see the para 2 of chief examiners.
After marriage, husband and wife relationship started. I have not given any statement except my statement recorded under 164. Today before this court, the accused has kept my other and also. But my lord, 161 the specific jo duita line.
Read it. That's the obviously 161 sheet.
But that confrontation is required.
That PW goes next PW.
PW is the 15 is the IO. Jo the victim.
IO, you want to ask IO?
Victim ko examine karla pore.
You can examine. Let 15 be examined.
Yes. 15, my lord, IO without examining.
Not necessary because this question which you are going to ask is very specifically asked in examination chief. She has said that.
My lord,
is implied that in 161 CSA.
Actually, my lord, what happened?
Don't try to
English sentence taku tikke bhul kar likhi di.
That is the whole. See, you are inviting a trouble by asking. This question can't be asked to her. You talk about PW 15 now.
PW 15.
I'll fix a date. Examine.
My lord, if PW,
you can put that question to PW 15 also.
3 ku pocharla pore city.
No. Just see the examination chief. You can confront examination chief.
My lord, I am fairly submitting your lordship. I am fairly
submitting. A larger experience in trial. Examination in chief. You have put very specific question to the victim. And confront with IO. Have you lost or not? Very simple.
My lord, what
Very
I'm fairly submitting,
What
my lord,
else?
the question is wrongly mentioned, my lord. I am admitting. The question is
You can't
wrongly
improve
mentioned.
now. You
But
can't.
the
There is
question what
change of-
needs to be,
Petitioner is agreed by the court.
my lord, last chance may kindly be
29.
granted without.
There is a bar, so therefore, otherwise I would have done it.
There is no bar, my lord. In the column, if your lordship allow me one day.
It's not an absolute bar.
Yes,
It's
your
my
lordship.
judgment.
Because
I am-
there is a word, my lord. Examination, re-examination also there, my lord.
But repeated calling.
Repeated
Expression is repeated calling.
in the 42 that stated it is
Second time
repeated.
calling is also repeat.
My lord, but in that provision, my lord, it mentioned, your lordship may kindly have that chief examination, re-examination. The word re-examination is there, my
Do you
lord.
want me to allow for 15 or no?
Both, your lordship. Last chance, I am ready to deposit the cost and I am ready to pay the transfer.
If you want you want to argue later on also, I will adjourn it, but I will allow only IO, not the girl. See, 17-year-old girl, you can't bring her to the witness box and asking questions after question whether you remain as wife and husband. All these questions, once you
Specifically, I will find
the
one
idea of POCSO is not to harass the victim.
victim. Yes, your lordship. The intention of
That is the reason 35.5, 33.5.
that, my lord.
33.5. So, respect that bar and proceed.
My lord, my last.
Otherwise, see, 15 I am saying, I am allowing you 15.
Your lordship, 35 to your lordship peruse. 35.
I have. You
Allow me one day time. Tomorrow I will satisfy.
Next week. Yes. That can't be ignored. But see, he's
Change of
facing-
lawyer, my lord.
See, the
Below
fact
10
remains
year
you are-
experience.
No, fact remains you are facing a serious charge. So therefore, you are entitled to cross-examine the witnesses. So therefore, IO you can do. Or I can very well say that you can lead defense evidence. You bring anyone. You can bring XYZ who can tell that yes, they were staying as wife and
My
husband.
lord, 17 fix achi eta for argument. IO examine already he selected.
Therefore, I am calling IO.
IO ko confront karte victim ta ko.
Take it is better advice that you.
But my lord friend should be content with what our lordship
Right.
proposing because the change of lawyer cannot be the ground for allowing a 311 mode.
My lord,
Because
below
it's
10 year experienced advocate cross-examine the victim. Below 10 year practicing advocate cross-examine the victim. After that, the council change his advocate.
That itself is not to allow
Latest judgment of 2020.
Petitioner, I am writing. A petitioner is agreed by the order dated 29/1/2025, whereby his application under section 311 CRPC for recalling PW 3 at PW 15 has been rejected. PW 3 is the victim in the present case, and PW 15 is the IO. The petitioner is an accused for an accused facing trial for an offence punishable under section 363, 376(2)(n), 376(3), 313, 506, 3(2)(v) of SC/ST Act and section 6 of POCSO Act. POCSO Act. The petitioner has sought for recalling the said witnesses to ask a specific questions which has been enumerated in the application. I have perused the questionnaire proposed to be put to PW3. In my considered opinion, the question proposed to be put to PW3, the victim, would also be put to the other witnesses or witnesses. Insofar as the PW 15 is concerned, the IO to defend himself, and IO of the present case is a vital witness. Hence, I am of the considered view that the petitioner should get a fair opportunity to cross-examine the IO. Cross-examine the IO. Hence, I'm inclined to allow his application insofar as PW 15 is concerned. 15 is concerned. Insofar as PW 3 is concerned, even otherwise, there is a bar contain a bar to repeatedly call the child witness, child victim witnesses under section 33(5) of POCSO Act. In that view of the matter, I am not inclined to allow the application for the PW 3, PW 3, next one. The trial court is directed to summon PW 15 by fixing the particular date. The petitioner is at liberty to, you need not confine your questions in view of the fact that I am not allowing 3. The questions which you have framed in so far as 15 is concerned, you need not be confined. You can ask any question to 15. Because I am not allowing 3, therefore you need not confine it. Right? Liberty to liberty to further cross-examine the IO. Examine the IO. However,
34, both the matters.
My Lordship.
Yes.
My Lordship, here the case is that on quashing of the FIR on
Copy of the petition has not been received by the
yes, madam. Let us see.
a copy I am serving now, my Lordship.
Oh, you are seeking quashing up for the FIR.
My Lordship.
Investigation is still going on.
My Lordship.
Investigation is going on.
Investigation is going on, my
Then-
Lordship. My Lordship, the fact
How
is
can it
that
be quashed?
no, my Lordship, let the CD call for what is the investigation, but interim protection can be given. Because the thing is that there is no evidence, no eye evidence also.
Evidence is yet to come.
Yes, my Lordship.
They are investigating. I don't know. If evidence will not come, then a closure report will be filed.
Let it be
How do you
investigate the matter. My
preempt
Lordship,
everything?
the fact is that they are keeping his uncle and auntie and they are torturing my Lordship.
Let them
Without any evidence, because previously the victim has killed his father.
You tell me what thing,
Already
while
he is
filing
in
FIR, all the evidence is required to be filed.
My Lordship, already the victim has completed 12 years conviction on death of cause of father. On that basis, he suspect. He suspect that he might have killed, but he has not seen. For that only.
Investigate. See, the offences are serious offences,
Yes, my
murder
Lordship.
and all.
Yes, my Lordship.
Like, how can I quash? And what you have filed? Only FIR, 2-page FIR.
Yes, my Lordship. Only affair.
How can I quash it? Tell me.
Let it.
I can't quash.
Report can be called for only.
Whatever you want to tell to the IO. IO will take care of that. There are allegation of murder and all. I can't quash it like this.
My Lordship, IA can be interim protection and or report can.
I don't know, madam, what are the evidence? It's a murder case. I without following due process, I can Arms Act, murder and all.
Let it be by the next.
You have to move before appropriate court. Appropriate court.
Lordship, by the next state, my Lordship can.
Don't spoil the case, and better you withdraw and approach the court at the appropriate stage. That's a better idea.
It's not possible.
Because
My Lordship. The main thing is that he has not seen and there is no evidence and
Are you
some
the IO?
suspect.
You are investigating the case. Then how do you know all this thing?
He suspect because he has killed.
All the
Already
FIRs are only
conviction is over.
suspecting only. Once there is a suspicion, FIR is registered and investigation takes place. And in investigation, they find out whether the suspicion is correct or not. Then, so this is the scheme of law. So nothing can be given.
Previously, another petition was filed, which was disposed of on 6th February 2025.
Same.
6th February.
Yes, sir. Your Lordship, kindly see the page 2 certificate.
What have you filed?
And the matter of which petitioner.
Anticipatory bail.
My Lordship, 6 to 2025, I had
You file
withdrawn
anticipatory bail, you file- what is
withdrawn
that?
the petition because of the error, typical error. I have withdrawn this CRLMC with liberty to file a.
And what is the anticipatory bail? Rejected.
Anticipatory bail that is
Rejected.
has been rejected, my Lordship.
If anticipatory bail is rejected, how can I protect you now? I can't do it. Withdraw it. Withdraw it. And
My Lordship, kindly fit.
I simply adjourn it. Okay. Adjourn it. Let us see. If charge sheet is meanwhile filed, we'll see. Adjourn it for 4 weeks. Yes, next. At the request of Learned Counsel, simply adjourn it. 35.
Please, your lordship, my lords. This is an appeal against conviction. The present appellant has been convicted under section 13(2) read with 13(1)(d)
What is the sentence?
of 3 years. My lords, may kindly see page 62 for a period of 3 years.
3
and
years.
to put a fine
Press
of-
appeal. Press
This
appeal.
appeal, another co-appellants, vide number 33 and 98 of 25. They have been enlarged on bail.
Okay,
They have
the
filed.
appeal admitted, bail granted, the realization of fine is stayed, and tag with
33 of 25 and 98 of 25.
25, and Mr. Sanjay Das appearance. Okay.
Grateful. my lords.
Yes.
36. 3 years.
Same order.
Regular appeal, 3 years.
3 years. Same. Yes. Next. 37.
2 years on each count.
Same order. Admitted and yes. Next.
39. Only 3 copies be granted.
Yes, please.
39.
39. Yes.
13 on the last option, the opposite party has taken time to file.
You can notice, sure.
39.
Yes.
Lord, sir, on behalf of Mr. Naik, thank for adjournment.
Adjournment. Also, the counsel for the opposite party, CBI, seek an adjournment. Adjourn to so and so, interim or to continue. Yes. Yes.
40.
This is Belgium Metro. Bail granted, Belgium Metro. Bail granted on 15/2/2024 and enrollment issued on 22/11/2020.
Okay, 500. Yes.
41.
Bail granted on 18/11/2014 and BW on 12/1/2023.
500.
42.
Published. 42, my lord, bail granted on 20th November 2021. The bail granted on 26th December 2021.
21.
Here, my lord, petitioner is not on court bail, my lord. Court bail se nahi. Kindly have glance, my lord. Order dated 26.
Okay, he will surrender whatever.
My
surrender. Not on the absconder.
He is on bail.
No. He was arrested in Atgad and executive magistrate granting bail while production.
My lord,
has
it
been-
is Atgad has granted bail, my lord.
Yes. The jurisdictional court has not granted.
He was admitted to bail in the premises. However, state counsel for the state dispute the same. According to order. Okay. Yes.
Published.
43.
43, may I please? The petition has been released on bail on 19/11/2012 and NDPS issued in 03/2 of 2014.
14. 15 under that. Yes. Yes.
44.
Obliged ones.
44 Belgium.
He is granted bail on 3/5/2023. Para 3, I have mentioned.
Yes.
The warrant issued on 28/2/2024.
Okay, 500.
45.
Yes.
45, my lord, he was also not, I am not clear he was on bail or not. But NBW has been issued. Kindly have glance, there is no averment to that aspect also.
They were
Kindly have glance the order, my lord.
petitioners on bail. NBW issued on 21/2020. 23 no, 2023. Okay. 500 each. Yes.
46.
46, kindly pass out.
Simply urgent. Yes. 47.
47, madam.
No, all the bail matter I'm adjourning because of the yesterday's judgment. It may be listed in this court or.
The date fixed.
Yes. Next. 50.
51. No, bail jaga rahiga. Kali no Supreme Court judgment on ye, wo court ko jibo decide out.
Yes, sir.
My lord. In this matter, they have filed an application for vacation of stay, but copy has not been served with me. If your lordship will fix a date, it will be hard and finally disposed of.
I'll simply adjourn it.
My lord. First week of March.
On the request. Yes, 51, 52, no? 52.
Item 52 minutes. Well, I had filed, IA number 786, 2024, I had filed for extension of time. In the meantime, I have already filed the original deposit receipt mailers.
Extension of what time?
My extension of time to file the
Deposit.
original deposit receipt. In the meantime, I have filed.
Deposited.
Yes, ma'am.
So then this
Then,
notary is required.
Next IMLS, I have filed for condonation of delay, but as per SR, there is no delay.
No, first let us see 789. This application 789, the application
786
for extension of time to deposit the awarded amount before the learned commissioner. Learned counsel for the petitioner submits that subsequent to filing of this application. Whenever you deposited,
Deposited mailers.
the award amount before the learned commissioner on so and so, and no order is required.
That was deposited mailers on 6th of September 2025.
No order is required. And condonation of delay application.
There is no delay. As per SR, there is no delay, mailers. So, Lakshmi kindly balance.
Condonation of delay application. That is the application 826 application. Although the application has been moved, but learned counsel for the petitioner submits that there is no delay.
As per SR, there is no delay. Noting is there.
The application is moved for condonation of delay for 7 days in filing the appeal. However, the SR report indicates that there is no delay, hence no order is required to be passed on this. Yes. Yes. I dispose of. Next, yes, sir.
Next, IU mailers, that is for stay mailers.
Yes.
Stay of disbursement.
In view of the order passed in 786 of 2024, the present application is allowed. Disbursement is stayed.
Yes, to stay the disbursement.
Disbursement of the award amount deposited with the commissioner is stayed. Yes.
In this case, I am for the claimant's respondent.
Yes.
I have already entered by appearance, my lord. In this case, my lord, your lordship will take up this matter fast to give a mark.
This the matter.
Fast to give
FAO
marks.
for hearing. All the IAs are disposed of and FAO for hearing.
It can be,
Also the instructions to appear for the employer. Okay.
my lord, your lordship keep this matter fast to give marks can be disbursed. Fast to marks.
Procedure of funds. Next. 53. Yes.
Appeal challenging the order of attachment and sale passed by the OPID court. There is a delay.
Where is the OPID council?
Copy. Last occasion direction was given.
How much delay?
There is a delay of 4 years, 8 months. I am
4
not-
years only.
I am not a party to the proceeding. Subsequently, I came to know my property has been attached.
Notice was issued already?
On the limitation, notice was issued last occasion.
Nobody is there. Reply has been filed? No.
No.
Notice on the application for condemnation delay was issued on 6/12/2024. However, no response has been filed by the opposite side. Even none appears for the opposite side. In the interest of justice, urgent. Yes. Yes.
Before. Well, I was for the respondent given part.
Yes.
My lord senior is appearing for the appellate.
In this case, my lord, delay of 175 days is there. Notice has not gone to the owner.
Are you opposing?
No, my lord. Is to go, I am let delay me condone, my lord, can be disposed of on the next day, my lord. Where I'm discussing for the settlement of the amount.
Settlement.
Yes.
I'll just record that and adjourn it, right? The learned councils appearing for the parties have conjointly submits that there is a scope of settlement in this matter.
No, your
They're
lordship, my lord,
exploring.
for that.
No.
Your lordship simply issue notice, fix a date, my lord. On that day.
On record, you don't want that.
No.
Okay, it's all right. Because insurance company, then problem. They will do it, but nothing to come
No,
on.
no, you're not
Right,
saying.
yes. issue notice on the application for condonation of delay. And so on, so accept notice.
To the respond
The
number.
matter for hearing. Yes.
Another application for stay is there.
Have you deposited?
Yes, yes, I have deposited.
Counsel for the petitioner submits that stay application. He has already deposited the award amount before the commissioner on
my lord.
Hence, the disbursement of the award amount so deposited
On 17/12/2024.
is staged until the disposal of the appeal. Yes.
IA number 40 of 2025, that is for stay, madam.
So I allowed it. Yes.
53 item.
Uh-huh.
Our name may be
Name. 53. Name. Your name is not there. Yes.
Sorry, Millet. 50 item, please. I am for the respondent. Item number.
That is over already. Yes. Next.
55.
Yes.
I am appearing for the appellant, my lords. The two IAs that I filed, one is for condonation of delay. There is a delay of 73 days in filing the appeal. And my lords, another IA is for stay of disbursement. My lords, I have deposited the entire amount. The receipt has been annexed.
Shall I condone the delay?
Yes.
For the reasons stated in the application, the same is allowed. Delay of 53 days.
73 days.
73 days is condoned. And insofar as the IA for stay is concerned, and counsel for the petitioner submits that the award amount has already been deposited with the commissioner.
That has been deposited, my lord. Before the learned commissioner, Jajpur. Learned labor commissioner, Jajpur.
On do you have the date?
Yes, I have given the date also. Your lordships may kindly see the date is on 8/11/2024. That was deposited.
Yes. Stayed till the disposal of the appeal. This is the appeal for hearing. Yes.
My senior has appeared for the claimants. He has filed a cross objection, my lords. A copy may be served upon me. And if your lordship feels it correct, then
the opposite party has filed a cross objection to the appeal, and a copy of the same will be supplied to the
owner has not appeared. If your lordship says, then I'll take note.
My whole grievance is this appeal is a false and defective.
When I'll hear.
Kindly see, my lord.
I am not hearing today.
For a moment.
I'm issuing notice on your objection.
Totally false.
I'm issuing notice on
suppressing the material facts.
I know.
I'm suppressed, my lords. Only a judgment has been annexed. What facts I'll suppress?
I am issuing notice on your cross examination, cross objection. I'll hear it. Supply the copy. Yes. 55. This is the 55.
My lords, 55.
But there is no IA. You haven't filed an IA for stay.
Yes, my lords. I filed that IA number, my lords, is 46. 46 of 2025. One is IA number 45.
Not highlighted. It's there. Okay. Leave the matter for hearing.
Next week, my lord. My lord, may fix it to next week because.
Next week, my lord, there's some difficulty. Let it come week after.
Give a date. You'll give a date. Yes, next.
56. I don't. 56 more appeal withdraw lagna. Ye withdraw kala. I am the appellant. It's a case of mode of payment.
Let us see who has given it.
Who has given the memo? I am the appellant. He is the opposite party.
Somebody mentioned.
Wrong. I am the appellant. It's a mode of payment. Railway 90% people mode of payment. I have corrected the order. 9 days delay.
56 na?
Delay.
Don't say 56 की कर दी थी उनको signing लो कौन ठीक है least it have
56 I have corrected the order.
Corrected order.
Mode of payment. Justice Rautre is passing usual order.
56 के कर दी 56 allowed
minor उड़ा को रखी दो जो fixed deposit till the majority.
Whatever you think.
This order is there in FAO 482. FAO 482 of 24. Your lordship's order is there.
Another matter 99. My other side is here, my lord.
Item 99.
Yes,
Item 99 we got here.
Also say my other side is here.
My name may be reflected.
You have written your name.
Name I have written. His name I have written. Jain Panda.
Jain Panda. Yes. 99, huh?
Yes, sir.
99. Yes. Yes. 57.
Item 57 minutes, I pray let it be listed 7 days after. In the meantime, I file the original deposit receipt.
It can also be disposed of, ma'am.
Huh?
We have discussed, it can be disposed.
Yes, discuss if it can.
Already discussed, my lord. On
I
that
will
day,
put it after a week or so.
a week after,
Yeah,
any time next week, my lord.
Yes.
You can bear.
A week after, because I will have to
Yes. Obliged.
date 30.
60.
And the extension of date of surrender.
Huh?
Extension of date of surrender.
Extension of
Date of surrender. Ma'am.
okay. Extension
Order.
for the reasons stated in the application, the time for surrendering appearing before the court, the petition is extended of the appeal.
Madam.
10th of March. 10th of March. 10th of March, it's made clear that no further extension. Yes.
May I please, ma'am?
There is a question that here. Petitioner in-laws. Notice be issued.
Petitioner?
And law in-laws. There.
Okay, 498A.
Steps to be taken.
Steps to be taken. You have to serve opposite party number 2.
Yes, sir.
Through IO, you serve.
Item is given.
Through IO, huh? Yes.
My lord, the opposite party number 2 managed to.
I for extension of time. I for applicable.
Which one? 60? 61. 61.
There is a IA number so and so is planned for extension of time.
No, you are appearing 61?
61.
That is 60.
Marking very clearly.
Okay, through IO, huh? Sub through IO, 61. 62.
62. Your Lordship, 62 and 63 are for the petitioners with respect to interim compensation. Your Lordship, I have filed to IAS 429 and 430 of a modification of your Lordship's order dated 14/11/2024.
What are the topic?
Your Lordship, as per that order, Your Lordship, we were directed to pay 10% of the interim compensation and rest was sent for mediation. In the meanwhile, we have entered into settlement negotiations and since that is still not coming to fruition, we are ready to deposit 20%, entire 20% of the interim compensation, if your Lordship permits us. And we also have the DD with us. We can hand over the DD to the opposite party.
20%.
20%.
50.
But you have settled the risk.
We are endeavoring, your Lordship.
Huh?
We are trying to.
Right.
We are trying to.
By the order dated.
One request, Your Lordship. While modifying the order minutes, the Lordship may kindly say that 20% of the amount is being paid in the court. Let that thereafter the learned court below may refer the matter to the mediation center for exploration of.
So then I'll dispose it up.
Yes, your Lordship. If your Lordship.
In this petition is agreed by the order dated 18/9/2024, passed by, where is that 18/9/24 order?
It's a GMFC.
Passed by JMFC Cuttack.
Yes, your Lordship.
In ICC number 86 up to 2023, whereby the application of the petitioner under section, application of the opposite party under section 143 capital A NI Act has been allowed, and the petitioners are directed to deposit 20% of the check amount as an interim compensation. While issuing notice, this court has, by the order dated 14/11/2024, directed the petitioner to deposit 10% of the check amount as an interim compensation and refer the matter to the district mediation center for exploring the possibility of settlement. The parties, the counsel is appearing for the parties submits that submit that the mediation process is going on. There is all likelihood that the matter would be settled. The counsel for the petitioner further submits that a person to the impugn order the petitioner is willing to deposit 20% of the compensation amount according to a draft
Dated 28 Jan 2020.
give the particular DD number so and so amounting to so and so has already been handed over to the opposite party, in view of the aforementioned development, nothing survives in the present section. According to the same is disposed of. However, the mediation process which is going on pursuant to the direction of this court dated 14/11/2024 shall continue and continued and the same shall be concluded. Concluded.
One
And the report shall be placed before the trial court after the conclusion of the mediation process.
Your Lordship, the mediation with respect to 80%, 80% of the amount, Your Lordship, is it for that, Your Lordship?
Obviously,
Entire amount, yes, more than
Just clarify.
whatever, obviously, 20% you have given, for remaining 80% you decide it.
Yes, sir. Grateful, sir.
Disposal, yes.
Receive signature.
64.
Ah, 64,
Item 64.
both are connected. No, see, what about 63? 60?
It's the same matter, Your Lordship. The case number is different. It's 87 of 2023, one CC now.
Okay, the same 20% here also you are going to pay.
Yes, Your Lordship.
I think 64, 60.
No, 64.
62, 63.
Yes, Your Lordship.
64.
So for item 64 is concerned, that the prisoner, other in-laws family, they have come up for quashing of the proceeding at pre-investigation stage, pre-charge sheet stage. I have the instruction to apply for OP number 2. Let's keep it next weekend. I'll my power.
So entered a petition for opposite party number 2 and seeks an adjournment. And submits that the parties have settled their dispute. Leave the matter.
Dispute is not likely to settle.
Likely to settle.
No. I am applying for OP number 2. Her husband and other in-laws.
Leave the matter up to this. Yes. 2 issue are yes.
65, my lord, I am for the petitioner. The notice on the sole opposite party has been made sufficient. Notice on the sole opposite party has been made sufficient, and the postal tracking report is at flag 8.
What is the report? Not sufficient. Sufficient. And the notice on the opposite party number 2 is sufficient. However, none had entered appearance as yet. In the interest of justice, please the matter on submission. Yes.
Other connected matters, my lord, similar.
66. May I please report along?
My lord, the challenges the order of taking cognizance in a protest petition, your lordship, and affair has been registered initially in 8% and protest petition filed against 18%. And thereafter, my lord, self-same allegation, my lord, the informant lost the affair in Annexure 5 and civil suit and Annexure 6 is pending filed by her husband, my lord. Husband along with others in the name of the villagers.
Yes.
Your lordship, in page 16, my lord, in which the protest petition filed, the 8 persons' name is there, 1 to 8 the petitioner's name. And that has also been registered in by virtue of the both the cases in CRLMP filed by the opposite party number 2, and thereafter they registered and the same has been final for, and 1 CC case has been filed. Protest petition in 18 persons, my lord. And 543.
Yes.
Page 54 is the Annexure 4 is the order of cognizance dated 21/6/24, my lord.
What is the ground why cognizance order should be required?
My lord, in the self-same allegation, my lord, one accused in the self-same occurrence in two affair has been filed in within short span of time, my lord. Your lordship have a glance. In 10/9/2018, this Annexure 1 has been registered, and second affair also registered, my lord. As per the 219 section, my lord, within a year, 3 cases has been tagged together, my lord. That is also there, my lord, in second FIR, my lord. You are annexed 5, my lord. I have annexed. One is the annexure 1, page 15, and another is page 55, my lord. And 16/12/2017, my lord. That has also been registered in the self-same occurrence, my lord, in 341, 294, 323, 354, 506, 34, and 31R and 31S registered between 3 persons, my lord. And the self-same FIR, my lord, 147, 148, 150, 452, 427, 294, 323, 379, and 506, 149, 31R and 31RS, and have been filed against 8 persons. And in that case, my lord, final form has been submitted, and thereafter, my lord, thereafter the protest petition in 18 persons, my lord. And the
one year back something had happened.
Yes, my lord. And civil suit filed by the opposite party number 2 by the husband.
See what are you saying? Just see the first FIR, annexure 1. What is the date?
Annexure 1, my lord.
What is the date?
Date is, my lord, in page 15.
10/9/2018.
My lord.
At 21 hours.
No, occurrence, my lord, intervention. 9/5/2018.
FIR is 10/9/2018. Okay?
My lord.
And the second FIR is?
Second FIR, my lord, your lordship, page
16/12/2017.
The occurrence date, my lord, by virtue of the order of this one.
Date of occurrence is
9/7/2018, my lord. Occurrence day, my lord. 8 occurrence date देखो occurrence date देखो ये CRLMP है लापर
occurrence date also just see occurrence date in the first FIR is 9/6/2018 and in the second FIR it is 2017.
17 within a year.
Same offense, same.
Same
Why are you saying that?
Lordship self.
Both the incident has taken place 1 year after.
Within a 9/7/2017 and 9/5/2018.
You are giving an impression as if one incident have happened, 2 FIRs are registered.
No. Within a year 219,
within a year, nothing, no FIR can be registered.
Pardon me?
Where is the bar?
No.
Legal bar?
No, my lord. But tag together, trial commencement भी हवा दी डागा खड़ी.
So what exactly you want then?
It is for the sake of convenience that your lordship directed to tag together both.
You have to move application before that court.
Or
I can't do.
Another point is, FIR was registered as 8 persons. But subsequently in protest petition, how the 18%?
But these are the
that is the
come to the protest petition. The protest petition, all allegations are there. What to do? What to do? You move application before trial. Better you move application before trial.
They have not 210.
Whatever application you want to move before trial.
All these points will raise for the 210 before filing the police.
Appropriate application before the trial court. If any such application is moved, the same can be considered on its merit on the basis of material available on record. With this liberty, the petition is disposed of. Yes.
Notice against opposite party number 2 has already sufficient, my lord.
Service complete? Anybody appearing? No. Or despite service on opposite party number 2, none had entered appearance as yet. In the interest of justice, adjourned to so and so. Interim order to continue.
21 to
68.
Your Lordship, in item number 68, I am appearing on behalf of the counsel for the petitioner, Mr. Jaideep Pal, who is on accommodation on health grounds. So if the matter could be taken up on any other date.
Petitioner is seeking, that's the problem. It is 138 case.
No, it's a complaint case, my lord. I'm for the OP number 2, my lord.
Yes.
I've already appeared. Entered appearance.
There is a stay.
Yes.
There's the interim order is there.
That is the reason.
If any short date can also be accommodated with.
May it remember another case is also pending on account of this case, my lord. That is here and limbs number 3470.
Release this matter on request, adjourn, the matter is adjourned to so and so. Release the matter along with so and
Here and limbs
interim order to continue.
70 of 2022.
Interim order to continue.
In both of the cases, interim order is there.
Yes.
The interim order may be continued.
Yes.
Yes. Yes.
70.
Seven zero. Right, please, Your Lordship.
Service.
Your Lordship, previously, Your Lordship directed for issuance of notice to OP 5 and 6. My Lord, when they filed bail application before this Honorable Court, my Lord, they stated this is my address and we are leaving this place. But my Lord, the noting itself stated no one is present that place, Your Lordship. It is fraud committed against this.
Despite efforts made by the petitioner to serve petitioner opposite party of 5 and 6, the service could not be effected. Hence, the IIC, which police station? IIC Talcher, PSC, directed to serve the opposite party number 5 and 6 and submit a report by next date of hearing. Release the matter on so and so.
When they availed the order from bail order, my Lord.
I know. Through
my Lord, grateful.
21.
Extension time for surrender, my lord. Extension time for surrender.
Extension of time. Extension of time. Surrender is
My lord.
granted.
My lord.
For the reason stated in the application, the same is granted. Time is extended up till 10th of March. It's made clear that no further.
My lord, cost ଟା deposit ହବାକୁ ହେଇଥିଲା district bar କରିଦା ମୁଁ High Court bar ରେ deposit କରିଦେଇଛି ସେଇଟା already deposit କରିଦେଇଛି 500 rupees ସେଇଟା
deposited.
ହଁ High Court bar ରେ କରିଦେଇଛି ସେଇଟା order ହେଇଥିଲା ଖୋର୍ଦ୍ଧା bar ରେ deposit କରି
submit that instead of the cost imposed on him, instead of depositing in the district bar association Khurda, he has deposited the same before the High Court bar association.
Oh, black man.
72.
Here, the last occasion while hearing question the bail, your lordship desired that to take up the matter for hearing. Again, it has come for listing for orders today. But I pray, my lord, your lordship kindly see page 63, running page, internal page judgment 55.
Lordship's last occasion directed this in the special area, your lordships. So why will hear the bail application and finally hear this matter? And lordship says text for
No, sir, this is bail application. This is an appeal, huh? Yes. We will hear it. You prepared any written note and all? You prepare it, I'll hear it and finish it up.
But today we have come ready, but my lord, they want some
time.
Let it be there in the board. Huh? At the top, at the top, at the top. Weekly list at the top. Okay. So that we can hear it and finish it. See, this is the appeal of 2024, but he is seeking for.
He was all along on bail during trial. And he was charged at 376.
What is the sentence?
376.3.
Huh?
Let me. 376.3 IPC read with section 4 of the POCSO Act and 366. And abduction and rape. Abduction he has been acquitted. When the very basis of the case goes, how or not, there is also no material, but prima facie 366 he has been acquitted. Abduction, kidnapping, I have
kidnapping part is doubted.
And how if I have not kidnapped her, how I committed rape on her? So that is why he was all along.
Weekly topper.
Yeah, that is why he was all along on bail during trial. But I pray your lordship may grant him bail so that.
No, I'll have to hear because 20 years.
My lord, the relationship between the accused and the informant.
I'll have to hear. Let us not waste time.
Teacher and student.
And put it at the top of the weekly. Yes. Huh? Let us see. Run through the list.
informant advocates also is there. Copy deposition.
Copy I'm pen drive नहीं give.
You take the pen drive, prepare the note and finish
Last
up.
occasion, your lordship directed them also to take in pen
Take
drive.
it in pen
They could
drive.
not take it.
No, you need not ask me. You take it in pen drive. It is not a classified document. It is your own evidence.
Yes,
Take it. Yes.
It will come on, it will come 4 weeks.
No, no.
ଆର ବର୍ଷ ଆସୁନି
Weekly leaves.
ଜାନୁଆରୀ ଆସିଲେ ଭଲ ଜାନୁଆରୀରେ ଡିସେମ୍ବର ଆସେ
No, no. Put it in the weekly list. It will be here. Weekly list at the top. You should ready Monday, Tuesday, anytime. If you get to the time, I will proceed. Yes.
with commencing from 17 or any day?
Not 17, 24.
Right?
24.
24, 25. I may not possible because some function is there in family.
Let it be on 24th. If you have problem, then it can't be over in one day. He has to argue. Thereafter, you will reply. He is there with you. See, if at all I'll hear it at 3 o'clock only, I can 3:30 only I can hear.
Because 24, 25, I may not be available.
Okay, it's all right. Let it come. I'll accommodate you on that day. If
some function there, that's why.
I understand it. Why are you worried about it? I'll take care of that. Don't worry. Yes. 73.
73, my lord. Lordship can have a glance to order dated 2011-2024.
20?
2011-2024.
State is called open to obtain up to
During the
date.
case of the I being the unfortunate father, filed this application because my son's dead body was found lying in a railway track. Being dissatisfied to the investigation, I filed this application for handing over the investigation to CBI or any other agency. They are the
Yes. Anybody is appearing for state.
No, union has already filed their counter. But so far the affidavit is concerned, which the state has filed, there the state is directed to obtain instruction because lordship can have a glance to the affidavit.
Yes.
Because in the report that stated the IO has sent a letter on 13/6/2024 to the public prosecutor waiting. Prosecutor available in the district court Baleshwar to give his legal opinion in the matter, and the state opinion is awaited. That is sent since 13/6/2024.
Do you have any clue about it? Huh? They don't have a clue. Maybe a change of thought. Already, Mr. Janar, and Constable of the State, submits that he has no instruction in this matter and seeks an adjournment to obtain a instruction. In accordance with the order dated 20/11/2024. Please the matter.
74.
My lord, in this case, I am for Union of India, my lord. My appearance may be noted. My lord.
It will come on next week, man, or
I will give it 8. Yes.
My lord, 74. My lord, the offense alleged against the present petitioner, number 1, is, my lord, under the POCSO Act. My lord, here your lordship wanted to hear me that in spite of the judgment of the Honorable Apex Court.
Are you ready?
Yes, ma'am. I'll
put it in tomorrow. Just put it in here because he has to address on that POCSO Act whether Ramji judgment is
I'll rely as Rosalind judgment as well as Ramji Lal Bauria judgment.
Yes. Then you find any subsequent judgment on that.
Well, till that, after that judgment, there is no other judgment. I have checked, subject to correction by Lord. My Lord is more updated than me.
Yes.
But I would say, my Lord, the Rosalind judgment, your Lordship has covered the point.
Covered everything. This situation is covered.
Yes, this situation is covered. And the judgment of the Honorable Apex Court, well, with due respect, I would say it will be distinguishable on this fact.
Only on facts you want.
Yes.
But there is no blank ban, what I understand.
No.
There is no blank ban.
If your Lordship sees that only last portion of the judgment,
somewhere 1-2 sentences are there which
no, my Lord,
problem.
Paragraph 32 is very important.
Yes, read it out.
In the decision of the by the High Court to quash the proceeding vis-a-vis Gyan Singh case and Lakshmi Narayan case in unambiguous terms, this court held that the power under Section 482 cannot be used to quash a proceeding based on compromise. if it is in respect of a heinous offense, which are not private in nature and have a serious impact on the society, when an incident of the aforesaid nature and guilt allegedly occurred in the higher secondary school, that too from a teacher, it cannot be simply described as an offense which is purely private in nature and have no serious impact on the society. Here,
in that case, can you say your case is also private in nature?
yes, because my lord, both the husband and wife are before your lordship. They have married. Now they have been blessed with 2 children. The father-in-law who had lost the affair is also before your lordship saying that I will not disturb my daughter's life.
You made it a private affair now.
It is a private affair. And now, my lord, the entire proceeding, if it is allowed to continue, it will be a otious in the eye of law.
Then Gansing comes then.
Gansing comes. The Gansing has not.
B.L. Joshi and Madhav Joshi also come.
But Gansing has not been set aside at all.
B.S. Joshi and Madhav Joshi also just check it up.
Yes, ma'am. The Gansing judgment, which has been referred to by this honorable or by the Honorable Apex Court, has not been set aside as a whole. It said that if it has a public impact, then compromise cannot be done. But if it is held to be private in nature, then it is 482, the hands are not tied of the Honorable High Court.
See, in that respect also, you just see the judgment. You see the victim is exploited.
Yes.
And left to the last.
Yes.
Then
it has impact on the society.
Then it is a offense against society.
If
she is not exploited per se, is not exploited, and she was not left in last.
No.
Okay. Rather is married. Then it is no more a society, no more a offense against the society. It is a private affair.
Here the case was the father compromised with the person.
So that that light,
and she was left in lurch. Some private persons filed moved the application before the Honorable Court. The Honorable Court took cognizance.
The POCSO, the legislative intention behind the POCSO is to stop the exploitation. Exploitation of
here we are these are before your lordship.
So therefore it is against the society.
Yes.
But once she is married and all the family members are, both the sides are
happy,
agreeable to that, then it is neither coming under the
it is not against nothing,
nor it is an offense against the society, no more an offense against society, because the girl is not left at last. That is the.
Well, this is the only point, your lordship. Closing.
Prepare no. Prepare a note and I have
yes.
Prepare a note and give in that light.
Yes, ma'am.
Yes. Keep it earlier date, because many petitions are. Many petitions. Once it is distributed, using that we can keep on moving.
My lord, in fact, my lord's judgment or that Rosalind judgment, my lord, that has covered everything.
I have covered.
My lord has covered this point also. If
by relying upon my judgment, I quashed many things. But
my lord, I would humbly say that if your lordship judgment would have been brought to the knowledge of the Honorable Apex Court, the Honorable Court, Apex Court could have written few more paragraphs explaining this.
At least that paragraph could have been.
Yes.
Let us see. Okay.
Interim order to continue.
Interim order to continue. Okay, sort the. Prepare a note, both of you, please. In that light, in the paragraph 32 light.
Yes, I'll prepare that.
Yes.
75, my lord. Here, the parties have settled the dispute. My lord, it was against 145 proceeding, which was converted 144, which was converted to 145. So now no more list remains to be decided. Your lordship may allow withdrawal of the same, but I only pray your lordship may allow a return of annexures 1, 2, and 4, the original certified copies. Take it from the office by your lordship's office.
Bose and counsel for the petitioner submits that the present ruling is arising out of mention initiated by opposite party against the petitioner under section 144 CRPC, and the parties have settled the dispute. So no,
my lord, they have approached the common law forum for hashing out their problem.
They have approached the common law forum for tracing out their differences, Hence, no more order is required in this petition. In that terms, the petition may be disposed of. Taking note of the aforementioned, the present petition is disposed of. The certified copy of the order dated.
Annexure 1, 2, and 4.
Certified copy of order dated. No, certified copy, please.
Certified
Annexure 1,
1, 2,
2,
and 4.
4. Maybe which is directed to return certified copy of 1, 2, 4. Annexure 1 to 4 by replacing photocopy of yes.
And my appearance that I was appearing for OP number 2 to 4, my lord.
OP number 2 to 4 appearance. Yes.
76.
76. Wrongly, I am forming with another file in the same name. I paid only one adjournment.
Okay. Get the request. Yes.
Entry for the conflict. Mediation fails.
2, 3, 70.
8.
Jesus, nobody is appearing once. He had appeared in every occasion, my lords.
Last time also non appeared. What is this case?
This is, my lord, against the enhancement of maintenance. I have come before my lords. The earlier occasion I had also made a mention. The husband is all along ready to take the wife and son. She, at the behest of her father, she is not cooperating.
What I'll do is I'll.
So much she has left.
No. What I'll do is since she's not appearing, I'll stay the enhancement. I'll stay that. That's the only thing. She's not coming. What to do?
May one more chance or through ISA, I will intimate to the cluster.
No, these are the proceedings arising out of what? Arising out of the 125. 125 proceedings.
127.
127, huh? 127. Why this police will come get him? 120, right? And this notice was issued to opposite party on
Annexure 9.
on 7/11/2023. Despite notice, the opposite party number 2 has not yet appeared. Next one, the petition is agreed by the order dated
18/9/23.
18/9/23,
Annexure 9.
whereby the interim maintenance or final maintenance?
No, my lord, enhanced.
Interim maintenance.
My lord.
Interim or
no? Interim maintenance, it has been enhanced.
Interim maintenance awarded in favor of opposite party number 2 has been enhanced to what is this? Enhancement amounts. What is the announcements? You say enhanced. What is the enhancement?
Enhancement, my lord, to 10,000, my lord.
Huh?
Yes, my lord, 10,200, 420.
From?
From, my lord, 2,500.
Enhanced to 10,000? 10,000?
10,420.
420 from 2,000.
And 7,000, 1 and 2. Mother and son. 10,420 and another is the son by 7,000. Why? 1,500 for wife and 1,000 for husband. It has been enhanced to 10,420 and 7,000. That is available to manage such space.
15,000, how it is enhanced to? Now you say 10,000. Earlier it was 15,000.
No, in fact,
be sure about what the figures are.
10,420 and 7,000.
Earlier it was 15,000. Now it is 10,000.
Earlier it is 1,500 for wife and 1,000 for son.
Where is that? Where is that?
Yes, it is available to manage such page 2. Page 75.
75.
Of Annex 9, my lord.
2,000 rupees.
Paragraph 3. But I am interested to pay, but I am ready to take my wife and son, but she is not coming. In the last date, my lords made a.
What can I do? Very difficult to, stay the maintenance of someone. They must be surviving on this money.
She is running a shop at her father-in-law's house. There is no fault. She has volunteered in the.
But now you take the at least you try. Take the notice.
Fresh notice. 3 times notice had issued. And he has appeared through advocate. For the wife, the name of advocate is there, my lord.
Despite something, repeatedly the matter is being taken up, but none has appealed the petition. Sorry, the opposite party. The counsel party petitioners is stay for the order dated, impugn order dated 18, impugn order dated 18/9/2023. So in the interest of justice, last opportunity is given to the opposite party to appear before this court. If on the next date appearing, none appears for the opposite party. Opposite party number 2, opposite party number 2. Necessary order for grant of stay shall be passed. Yes, good clarity. Yes.
79. I am before your lordship for quashing of Annexure 1. My lord, Annexure 1 has been lost by the informant at about 9:45 AM. But my FIR is earlier to it. That is Annexure 2. And keeping all the aspect in view, your lordship was of the view that the matter may be sent for mediation. Mediation, they didn't cooperate. Mediator's report is there. Your lordship may kindly see the mediator.
Nobody has appeared here also.
Hey, please, your lordship. I'm appearing. Comment, your lordship.
But every time they.
Yes, madam.
Yes, your lordship.
Matter was sent for mediation.
Your lordship, however, the petition, the informant is not interested for mediation, your lordship.
Who is informant?
Informant in Annexure 1. Informant is opposite.
So you are appearing for whom?
I am appearing for the petitioners, those who are accused person in.
She says that she is appearing for.
She is appearing for the informant.
Yes,
you are appearing for informant.
Yes, your lordship. Opposite party number 2 in the present case.
Why are you not cooperating for mediation process?
Lordship, we have attended the said mediation process. However, Lordship, the opposite party is not interested and she want to pursue the case, your Lordship.
So you want to pursue the case?
Yes, your Lordship.
My lord, if pursue the case, your lordship may kindly see Annexure 1. What is the allegation?
I have stayed it to let it be stayed. Continue.
My lord, what has happened in this case? Petitioner number 2 of the petitioners are government employees. One is a OS officer and 2 are also the students. Because of this case, the students are suffering because they have if they will appear for any competitive examination, they have to give whether any criminal case is pending or not. So for that, they are also suffering. 8 and 9.
What are the offenses?
Offenses made out under section
341, 323,
323, 294, 354.
Investigation is going on or charge?
The charge sheet has already been submitted. I have also filed Annexure 3.
Trial action state that may kind of considered.
Sorry?
Lordship, in the meantime, only charge sheet has been submitted and it prima facie shows there is a case under section 341, 323, 294, 350.
Madam, what are the allegations? If you are so adamant that you not participate in the mediation process in small crime, you want to jeopardize the career of these students.
Your Lordship, with regard, I have taken
If the court says that you participate in the proceeding, you have no option. You have to go and participate. You can't be adamant. The adverse inference will be drawn against you. We are not heinous crime, 323 and all. You can't, prosecute the young students, jeopardize their career. I can understand if the offenses are very serious, I can understand. What kind of allegations?
Lordship, the accused, the
Merely
victim-
because they are vulnerable doesn't mean that you will keep on, this thing. What are the allegations? Let's see. What are the allegations?
Annex 1, your lordship, page 13.
Obstructed her and abused her. That's all. And in the FIR, you have implicated the 9 people, obstructed you and abused you. That's all.
Case counterfeit.
Yes.
So case counterfeit, and that is the only allegation. Is
I was very small allegations.
In the language in the public place, lots. That is the allegation. Parts in the public place, wrongful restraint and assault them or address the modesty of complaint with threatening against the direct consequence. That is the allegation.
These are the allegation, and just see 2 young students, college-going students, and one of them are
One officer, police officer, 2 government employees. And your lordship may kindly see Annex 2. What are the allegations against them? And my.
Yes, madam. Will you will advise your client to participate and
I will take instruction, your lordship. One more chance may kindly be granted.
no instruction. She has to participate. Otherwise, I'll quash it.
I will advise
You can't use judicial process for settling your score like this.
I will advise your lordship.
Tell advise your client to participate in the mediation process and conclude it, because there are cross case. Both the cases can be settled.
Yes.
If offenses are not at all serious. Yes. Mr. Sudha Prasanna, the counsel for the petitioner submits that despite this court referred the matter to the mediation center of High Court. High Court, the opposite party number 2 has not cooperated. Hence, the mediation process has not yield any result.
Mediator has already filed the report.
Not yield any result, and accordingly, a mediation report, mediation report dated 23/10/2024, 24, stating that the mediation become unsuccessful has been placed on record. Ms. Adhya Shakti Priya, alternate counsel for the opposite party, submits that she would persuade her client to participate in the mediation process once again, and try to settle the dispute. Regarding head to the nature of allegation made by the opposite party against the petitioner, and explore one more opportunity for explore once more for settling the dispute through mediation. The parties are again relegated to mediation center, High Court mediation center, to explore the possibility of settlement. Release the matter on so entry mode to continue. Yes.
Interim order to continue.
Entry mode to continue. You participate. Tell your client.
Yes.
Participate and finish up. Yes.
May I please, your lordship? In this case, my lord, mediation failed, my lord. The challenge, my lord.
Failed. Mediation failed.
Yes, my lord. My lord, in the case, challenge the enter DV proceeding, my lord, by the in-laws as well as the husband, my lord. The DV proceeding has been initiated after the gap of 6 years of the dissertation, my lord. Residing together since 2015, she has left the in-laws house.
Well, here mediation failed. Mediation, the matter was referred to mediation, and the
maintainability of the present application, or lordship. Maintainability of a present application by abusing the process of law, lordship. The DV proceeding initiated in the year 2017, lordship.
Yes.
Then interim order passed.
2020.
Then interim order passed. challenging that interim order, appeal before the law and judge. That has been dismissed. Challenging that appeal revision before this honorable court. That has been
What is happening in the marriage front? Marriage front, what is happening? Marriage. In the marriage, they are staying together?
No,
After
1
they are now they are residing separately.
After the 1 year after the marriage,
That's what. Have you anybody filed a divorce petition?
Divorce petition, I have filed.
That is pending, Your Lordship, for disposal.
I'll hear it. The time will heal everything. Yes. The mediation has failed, and accordingly, mediation.
So no order has been challenged, Your Lordship, only due to interim order, Your Lordship. The proceeding is held up.
Leave the matter for hearing. Yes, next.
Next week, madam.
Another 10.
81. Here, FIR and counter FIR civil dispute. One of the complainant before this honorable court in an anticipatory bail had said, I don't want to pursue with this litigation. Anticipatory bail was granted. Your Lordship had towards the view of petition whether they were present on the last date. They have also filed a joint petition and sworn the affidavit before the oath commissioner. That is with my learned friend is appearing for the complainant. With the parties can be referred to mediation, it can be resolved. There's a joint petition also.
They will be referred to mediation, madam. There is a chance of
the petitioner is an accused in FIR number 22 for alleged offences punished under section 4. The petitioner is seeking quashing of the FIR on various grounds. Mr. Maharana, learned counsel for the petitioner submits that when the petitioner applied for anticipatory bail before this court, the petitioner, the opposite party has filed affidavit.
Filed an affidavit. That is that page 129.
Entry stating that he doesn't want to proceed against the petitioner on the basis of the said affidavit filed before this court. This court has enlarged this court granted the concession of pre-arrest bail. In view of the said development, he submits that the matter could be settled through mediation. Then counsel for the opposite party also expressed the similar view in similar view. Therefore,
so
I'm
joint
inclined to refer the matter to High Court, awaiting the mediation report, release the matter on so to continue.
One correction, considering that affidavit, this honorable court noting that affidavit that she doesn't want to proceed, relegated the matter to the lower trial court to consider the bail, not granted bail, relegated the matter. The order reflects that the affidavit has been filed. In view of the affidavit filed,
granted anticipatory bail, taking note of the affidavit, this court relegated the matter to the trial court for consideration for regularity. And accordingly, the petitioner was
disposed of. Anticipatory bail was disposed of.
The petitioner was admitted to regular bail.
That order is there at in the brief.
It's all right. Yes.
And the joint petition is there. I'll file it with the registry. And it's interim order to continue.
Interim order.
Obliged.
Yeah, please. In this case, petitioner.
Yes, madam.
My lord, petitioner challenging the cognizance order dated 26/2019. My lord, last occasion, this honorable court issue notice to the opposite party, also directed to the mediation for mediation. My lord,
what is happening in mediation?
Mediation report. I have no instruction, my lord.
Mediation.
That is
mediation failed. The matter was referred to mediation by the order dated 4/9/2024. However, the mediation report indicates that the process of mediation has it will become unsuccessful. Where is mediation for unsuccessful? Liability.
There is a civil dispute between the parties, my lord.
This is a matter for hearing. Unsuccessful, hence the matter is listed for hearing. Yes.
Obliged.
My lord, appearing on behalf of Mr. Panda.
Yes. Yes.
My lord, I have the 183 BNS statement of the victim, and just the bare reading of the statement shows that there is no offense made out against the petitioner.
Yeah, what is the stage of the investigation?
My lord?
What is the stage?
Stage, my lord.
Your lordship, charge sheet has been filed.
Where is the charge sheet? Where is the charge sheet? Where is the copy of charge sheet? Yes, do you have any idea?
No, my lord.
Charge sheet has not been. Charge sheet has. The POCSO is there.
Charge sheet. Are you seeking quashing?
Yes, POCSO is there. Quashing.
Lord, I have the 183 statement.
Oh, by an affidavit, this can't be done like this. Where petition is seeking quashing of the petitioner is one of the accused in the FIR number so and so registered against him by the father of the victim. Father of the victim girl for alleged commission of offences punishable under section 11 so and so with POCSO Act. It is informed of this after investigation charge should have been filed with the case. The petitioner, by relying upon affidavit filed by the father of the victim, dated 1/10/2024. 1/10/2024 submits that the petitioner, the father of the victim, in the affidavit before the court has has stated that he has reduced the age of her daughter by 2 years. But at present, her daughter is major. Relying upon the affidavit, the petitioner is seeking quashing of the present proceeding. Relevant part of the affidavit is worthwhile to reproduce. Affidavit, it is para 2, 3, 2 and 3. Para 2 and 3. 2 and 3. I am not inclined to entertain give indulgence to the petitioner on the basis of the aforementioned affidavit. Once the charge sheet has already been filed. Charge sheet has been filed. Hence, the petition calls for no interference according to the same legislation. Yes. Yes.
87.
Yes.
87.
Non-APS for the petitioner, non-APS for the party in the interest of justice. Yes.
88.
I am for the complainant.
Your Lordship,
One-
Your Lordship, I am for the petitioner. Due to personal health issues, Mr. Lal cannot appear, so kindly give us time.
But I am not opposing on the health issue, but your lordship will fix a short though.
Yes.
Because here the 138 proceeding has been stalled.
There is interim order in
The
138
interim,
proceeding.
interim order shall be continued. It's my humble request.
That's the difficult, that's the reason
Yes,
he.
yes, yes, sir.
See, this 138 proceeding initiated when?
2015.
Just see 2015 proceeding, 2014. Taken a
It's my
stay.
humble, it's my humble request. Kindly give us
Okay.
short date only.
Okay, right on. On behalf of Mr. F. Lal, I advocate for the petitioner. What is your name, madam?
Subhashri Mishra.
Subhashri Mishra, and counsel for counsel. Seek an adjournment on the ground that Mr. Lal is indisposed. Mr. Bose, and counsel for the opposite party, submits that the present case is arising out of a 138 proceeding pertaining to the year 2014 because for the stay for the proceeding because of the stay order the proceeding is stalled. In the interest of justice, to so interim order to continue. However, it is made clear that no further adjournments are being granted in this matter.
I pray your lordship will fix it short date.
Short date, yes.
But they are relying upon that Lalit Beriwal judgment, which I had argued before on Justice Knight. I will make a distinction that it is not in consonance with Lalit Beriwal. That is the only thing.
Yes. 138 matter, madam, it can't be stayed. Once it's stayed means you have to do it. Yes.
Yes, Lordship.
I have adjourned it on your request and extended the interim order, but next date.
Yes, sir, definitely, Your Lordship.
Yes.
Grateful.
Much obliged.
90.
My petition to cancel the bail of the opposite party, having rejected, I have approached your lordship. Last package,
For the interference,
Notice.
I am for the opposite party. Is a transport bill. Today only I have filed my appearance.
You file reply.
I have filed my appearance in the
One thing I will submit. Here in the case, the bail has been granted with the condition that one of the bailers should be his relation. Must be relation. And here the bailer, according to own admitted bail bond, he is not a relation. And illegally the bail bond was accepted. Second, the bailer was a professional bailer who died much earlier than the execution of the bail bond. Impersonating a person in the name of X, Y was impersonated. So on these two grounds there, what I pray, your lordship may grant him time, but let the officer in charge concern be directed to find out about the bailer. There is nothing to laugh here. No, I don't say. No,
I can do.
All right. All right, allowed. If the court allows that, I can't.
We can laugh or smile.
Let him file the objection. If what objection?
I pray that, but within the time, your lordship may direct the concerned officer in charge to find out about the availability of the bailer, or your lordship may direct my land friend to produce that bailer.
My lords, already
that bailer,
while disposing of rejecting his application, conducted the inquiry and did it. This
No.
order is challenged. That order is under challenge. So this court is not going to find out the truth of it. Whether the order is correct.
Inquiry is already done.
No. Order is correct or not. That's what he is challenging.
No. No inquiry was.
Where is that order? Let us see.
He has filed a submission, written note or something. Let him serve a copy. I file a counter. And no urgency is there because the person concerned is in custody in another case, connected case. So what cancellation is?
There are a number of cases. He's a master.
Urgency is there.
No, it is only technical concern.
No, not technical. Here the point is that, my lord. Here
I understood, but he is already in custody.
So that is not the concern. The whole point is that
is from jail. I filed today.
In other cases, yes, they have misappropriated crores of rupees of the complainants. Crores, around more than 50 crores, or it may be around 20 crores. Here, what happened is a bouncing check case. She had given an address which was not correct. She appeared and thereafter did not take steps for which NDPS was issued, could not be executed. Thereafter, behind the back of the complainant, he filed an advance petition. She filed an advance petition, got the bail in the order, impersonated a person who is a dead person, and without furnishing satisfying a relation, because the bail bond, the order is that, your lordship kindly see the order. I have given the memo with one surety who must be relative of the accused.
You show me any document that.
Yes, that is there.
Where is that document?
No, he is not a relation. I have stated on affidavit.
No, you say that the bailer has died. Show me any document.
No, I have stated on affidavit. I have stated on affidavit.
The trial court says that in the absence of a proper document regarding the death,
that is to be verified.
no conclusion can be drawn that in respect of the basis of oral submission.
No, it was filed.
That is the reason it is.
No,
show me any document.
Documents were filed. Paper publication was given.
I'll tell you, these are the offences under 138(9). These are bailable offences. Bail has been granted. Why should the court, 482 court will interfere for that?
Your lordship
and you made an oral statement that the bailer has died.
Uphold the dignity of your lordship's court only. Your lordship directed, if it will not be complied with, then again if you be exonerated, then
I'm not saying that. Let him file the reply.
What I say, let the
I will not venture into an inquiry now.
No, not inquiry. Just to find out whether that bailer is available or not.
Because you show me any document that he has died.
Paper clipping the radio.
What are those documents?
You have stated an affidavit. Your lordship can see.
No, not affidavit. You show me the documents so that I can venture into. I see whether bailer is dead or alive. The trial court has conducted a inquiry kind of thing.
No inquiry. No inquiry.
That's the order says.
That is the purpose. That's what I have.
You let him file the reply with the get him. You file the reply.
Yes.
Within a week or so.
Of the written note.
Please give the written note and let him file Mr. Sargi and
only to save the time I was saying to your lordship.
Okay, opposite party number.
Why the unnecessary time?
Opposite party within a week lease the matter. And if you want to file any document, I am giving that. Mr. Mishra.
We have filed the law. Your lordship call for the records.
No, have you? Do you have any document to file further?
No.
Okay.
No further document.
If any, to be filed, maybe filed.
Your lordship may call for the records. I will share.
Thereafter, let him file in the counter. Yes. Please the matter. Yes. He's in custody. No problem.
She is in custody. Madam, may I record that I have appeared.
Yes, I have entered it. Yes.
His daughter is saying it came out in paper. His daughter is saying in press media. So that is the thing. We say so. And he claimed to a relation, and he himself has stated in the bail bond that I know him for 7 years only. If the relation would have been there, how can the bail bond he would have right? She would have right.
Yes, next.
Man.
Both the matters. Two matters are there.
That too.
Yes.
Two matters are there.
Two matters, not both the matters. Yes.
91.
Any mentioning now? I don't think.
Lord, item 100, my lord. It has come in the hearing part, my lord.
Even in the morning,
1 minute, 91. I'll just say yes.
My lord, item 100. My lord, this is a case challenging the veracity of the will, my lord.
Now, what do you want?
My lord, I have filed one IA for status quo, and earlier I had granted one status quo, but it could not be continued thereafter. It was ended on 24th April 2024.
The 2012 matter, madam.
Yes, my lord. My lord, one status quo order has been granted. I am seeking that status quo order to be given again, my lord, by filing IA. I have filed one IA.
No, what is this FAO?
My lord, this is about challenging the veracity of the will. My lord, will. Probate matter, my lord.
Testamentary
Probate,
case.
yes, my lord. Probate of will. Where in one probate application, my application. My lord, I have informed the opposite party. My learned senior friend Samir Mishra is. My lord, it should be. My lord, may I pray it may come in the order. I have filed one.
It will come in the order.
Yes, my lord.
It's a hearing matter. Because for status quo order, I have to hear at length.
Yes, my
I
lord.
can dispose of the appeal itself. The amount of time I'll spend, I can dispose of the appeal.
Yes, my lord.
That's a better idea.
My lord, my only predicament is that during the pendency of this FAO, all the properties are going, are
See,
on
this
the
is pending,
process of.
Madam, this is pending since 2012.
Yes, my lord, it is going on.
And all of a sudden, today's status quo makes neither here nor there.
Lord, I have already granted with the status quo. My lord, it was
Then
on
you file a
30
contempt if the status quo order is violated. File a contempt.
My lord, it was ending on 24th April, 24. Status quo order was granted on 31st 1st 2024 because they have started constructing on the property.
Okay,
They have
30.
31/1/2024. It is clearly written कि in the meantime, the appellant is selling out different patches.
Till 24th April.
Yes, my lord. My lord, thereafter.
What happened in 24th? 24th matter was taken up.
My lord.
The interim order shall continue.
That could not.
Thereafter, what had happened?
My lord, when they did not stop construction.
The interim order, status quo order is continuing. What are you talking?
No, my lord, it is not continued.
It is continuing. I can see. Just see the order. If you have not read the order, then continuing.
My lord, I have filed one contempt application. That is also
That's
pending.
a different story, but status order is
My
continuing.
lord, that may be tagged with this.
Keep it.
6502 of 24.
My lord, item 97. Keep this matter on 25 in this month, my lord. Can be disposed. Other side is there, my lord. It is
20?
97. 97
25th of.
Interim order is there that.
in entry order to continue. What is the rule? Both parties are.
Item 95 conducting counsel's mother expired, that will be taken up 2 weeks after.
Okay,
Item
2
95.
95 2 weeks after. Okay.
Item 93, the pleading has already been completed and your lordship was about to reserve for.
I know.
So I pray next week my the vigilance council is not present now. So I pray next week interim order. Next week any date maybe.
96. 96, yes.
96. This matter can be disposed of, but only though quantum has been settled, but only one ground has to be recorded. Only I will take 1 minute. If you allow it, not possible, let it be tomorrow. Yes, your lord.
Tomorrow. Day after.
Interim order to continue.
My lord, 94. 1 year.
Interim order to continue.
Item 86, my lord. My lord,
let me pass the order thereafter only. Yes. 94 on request adjourned and interim order to continue. Yes, you tell me.
My lord, item 86, I beg your apology. I wasn't given proper instructions, my lord. A charge sheet has been filed. I just received it.
I know I have recorded that. I know I have recorded. Charge sheet is filed. Yes. They give the date of charge sheet.
My lord, charge sheet is here.
Charge sheet order already लिखी दी थी 86 ना 86 charge sheet और date लिख दो charge sheet date of offense yes
my lord this is weekly 96
86 समझ चलो मतलब charge sheet has been filed on certain day for the commission for offense
short adjournment
weekly 96
short adjournment my lord.
Which one?
86.
I have already disposed of. Yes.
My lord, weekly 96. This is a vigilance case. I have been dismissed from service for 5,000 rupees, which was found from my office when I was not there. I was 200 meters away. I have been suffering for 8 years.
96.
96, my lord. Weekly. Maybe
weekly 96.
My lord.
Weekly. Let us complete this later.
Okay, my lord.
Weekly.
Yes. Please to fix a date, my lord.
100.
Because I am there, that's for hearing.
I fixed she was asked to fix.
That's a probate matter, my lord.
Yes. I fixed the date. Yes.
Come up.
91. Now everything is over. Now 91. Let us see 91.
POCSO Act under the case.
The present petitioner filed a petition under 34 subsection 2 for determining the age of the victim before the learned court below, my lord. The learned court below examined 2 court witnesses. One is from the Hon'Ble center and one doctor. Another is from school. In both the matter, my lord, the doctor said the age of the victim is 2009 some month, and the this side school said the age of the victim's age is 2007. Now the learned court below disposed the petition saying that 94 subsection 2 of the JJ Act said The first preferential is the school admission register. But my lord, the victim cast her vote in the 2024 election. She have the birth details in the showing that is showing 2009, and they are relying on the school document that is as advised by the parents and guardian of the victim, your lordship. Whether that is valid or the other documents are valid, where the voter ID is valid, that is the question before this one.
Voter ID is a self-declared.
Under People's Representation Act.
The main.
Have you franchised
the primary document.
No, that's right. Rule 12
is the school living certificate.
Yes, but have you really participated in the election?
Yes.
Have you given the vote?
That I don't know.
Yes, my lord. I have the copy for lordship's kind perusal. This is the
voter list.
Voter list, and she cast the vote. In the voter list, the age is 20, my lord. She saying I am 17 now.
When it needs hearing.
School admission register is very clear.
It needs hearing. That contemporaneous documents are also there. After all, he is facing a POCSO case.
My lord.
Otherwise, straight away POCSO goes.
I am saying only
No,
POCSO
needs
is
hearing. Needs hearing. I thought yes.
Interim order may kindly.
The law is very clear about the determination of age. So far as the Juvenile Justice Act is concerned, and so far the POSCO Act is concerned. Both the acts
If the difference is little, one can understand.
Yes.
If difference is huge. And contemporaneous documents are there.
15 ବର୍ଷ 9 ମାସ 3 ଦିନ date of occurrence because the relationship is 3 years back. So 373 is also there in the charge sheet along with POSCO. And now he is stating by showing the voter card that since he has casted the vote.
FIR is after 3 years.
3 years.
Yes. The continuous relationship.
The date chart I have already submitted, my lord. In the 2024, she is saying I'm prior to 3 years. Means at the age of 17. At the age of 17.
Those things are different.
My lord, at the age of 17, she has a relation with this petitioner.
Prior relationship, continuous relationship will not
isolated incident and all.
Yes, sir. Not act like 373. It will also allure to my benefit also. Today I will appear from that side and show the judgment to my lordship.
Right.
It will also allure to me also. But I am not on the particular facts of this case. But Aadhaar card, voter ID card, PAN card, driving license, 4 documents. All documents are self-declaratory in nature. They cannot be used for determination of the age of the victim or a juvenile. When a criminal proceeding is going on. Criminal proceeding.
This point you have to meet.
But my lord, at the time of birth, at the time of birth.
Date of birth.
But what is that judgment? That what is the name of the
Journal?
No. Subsequent judgment. Where they say that Rule 12, interpreted Rule 12.
Yes. Rule 12, that is with regard to determination of the age of a juvenile.
Juvenile from child in conflict with law.
Not the victim. Not the victim.
Victim is section 34, subsection 2, my lord. Section 34, subsection 2 of the.
But they determined, they have elaborated Rule 12 and said that which document will supersede other documents.
My lord, case to case varies. If there is no other documents, then school admission registered. But here the birth details is there, my lord. The first document is birth details. School admission रे बापा ना जा डेट दियंती सीटा लिखी दियंती आगे.
School register.
But birth admission को deny करी परिवेनी.
Let us see.
Yes, sir. Arguing that, but give this matter to any day at 2 p.m. It needs a little bit more time for hearing. Any day 2 p.m. I don't have any.
25th at 2 p.m. 25th.
2 p.m.